item number 5. I was supposed to file an additional FATP.
Yes.
Lordship, we come to know that they have approached learner CAT also. So Lordship, allow me another 10 days time to file additional FATP. So we on record from the please.
Mr. S.C. Cal, Learned Counsel, Learned Standing Counsel, CBIC.
Lordship.
CBIC?
Lordship.
CBIC. For the petition has sought listing of the case after 10 days in order to file an additional affidavit.
Much.
First of the Procedural, list the case when?
First week of January, March, Lordship.
1st of March?
Lordship. March.
May please, Lordship. This matter, land eviction matter, madam. We have filed Saturday, madam. Let it come day after tomorrow, madam.
My lord, I beg to mention item number 12, my lord. There is, my lord, some development is going on, my lord. After 10 days, my lord. Okay. On the pair of Mr. K.U. Ahmed, Learned Counsel for the petitioner, the case is passed for the public.
May I please, Your Lordship? I beg to mention item number 29, my lord, the concern on the other side, my lord.
29.
29, my lord. Here, I'm to file my affidavit reply, my lord. I
Okay.
pray for 3 weeks' time, my lord. Taking the
Mr.
concern.
M. Dr. Learned Counsel for the petitioner has paid for and is granted 3 weeks time to file affidavit in reply to the affidavit in opposition filed by the respondent APDCL.
My lord.
This is the case after 3 weeks on a date to expect.
Simply apply.
Lordship, in item number 37, we have filed an additional affidavit that may be called for, Lordship, on 16.
May I please, Your Lordship? Item number 9, kindly be passed over for the day only, my lord.
Okay.
For the day only, my lord.
Your name?
A Khan.
On the prayer of Mr. Ekant, Learned Counsel for the petition, the case is possible for the day.
May I please, well, on the joint prayer of the petitioner and the respondent number 4, I beg to mention item number 21, my lord. This matter is wrongly listed today, my lord, although it is fixed on tomorrow, my lord. And second thing, my lord, the respondent 4, my lord, he is from Biswanath Sariali, Development Authority Council. So he conveyed me over from that it will be difficult for him to come first week of March also. So on both pair, your lordship may fix it on 27th of March. It was actually
Supposed to be listed on 21st.
Lordship may kindly fix it on 27th of March. He has some difficulty. He is outstation, my lord.
22nd?
22nd, man.
Okay. On the prayer of Mr. B. Borua,
Yes, man.
Learned Legal Aid Council. List the case on 22/3/2023. 4. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer.
May I please prepare for listing the admission matter any day of this month, or last week of this month.
Subject matter?
Subject matter regarding the land acquisition, Lordship. I am for the respondent, private respondent, Lordship. Our village path was acquitted by the government, Lordship.
Huh? Your
Our village road, Lordship, road path. Lordship.
village?
Road, Lordship.
Road.
Road, Lordship. But petitioners approached this honorable court that the government not properly acquitted their land.
You are not the petitioner.
I am the respondent, Lordship. We have
Yes.
difficulty that our road is already stopped, Lordship.
Which stage? Admission?
Admission, Lordship. Any day of this month.
Sorry,
May I please, Lordship? I beg to mention item number 35, my lord. I have taken from, I have taken consent from other.
35.
35, my lord.
Hmm.
In the matter will come up after 2 weeks, my lord.
Okay. Mr. A.K. Azad,
Last-
Learned Counsel for the petitioner, has paid for listing of the case after 2 weeks.
My lord.
You have informed the other side.
My lord, I will.
It is submitted that consent has been taken from the Learned Counsel for the Learned Standing Counsel Cooperation Department to make the prayer. Price allowed is the case of.
Always.
May please, Your Lordship. Lordship, this matter for related for tender matter, Lordship. In
Men's sport.
Saturday, Lordship, it has been allowed, Lordship, for men's Lordship.
Sport.
Okay.
May I please, Lordship, I beg to mention for listing of an admission matter, my lord.
Subject matter.
Subject, my lord, we have prayed for expedite of a investigation process, my lord, which is pending before the CID, my lord.
Sorry, brother.
Obliged.
Lordship, item number 48, Lordship. Lordship, we have some urgency, Lordship. May I pray first a little bit upgradation, Lordship?
48.
Lordship, last 2 occasions, it has not reached, Lordship.
We can't help with every List is taken up whenever possible.
Lord.
See,
My lord, with the constant on the other side, I beg to mention item number 20, my lord. Mr. A. Sharma is RO station, my lord. Let the matter come after 1 week.
20.
20, my
You have informed the other side.
my lord.
Your lordship, the matter may be fixed on 5th March. 29, then 29,
Not 5th March.
29 February
6th of March.
to 6 March.
Obliged, my lord.
Okay, Mr.
S. Chaudhary.
H. Chaudhary, Learned Counsel, appearing for Mr. A. Sharma, Learned Counsel for the Respondent Oil, has paid for listing of the case after 2 weeks, as Mr. Sharma is stated to be out of station on personal ground. First of Miss
B. Shah.
B. Shah, Learned Counsel for the petitioner, is present and has no objection to state prayer. Lays the case, as sought for by the Learned Counsel for the parties, on 22/3.
But
22/3 or 6/3? 22. 22/3 or 6/3? 6/3. 6/3.
but
May I please, your lordship? I beg to mention item number 3, lordship.
3.
Lordship. This matter may be adjourned for 1 week,
Hmm?
lordship.
Okay. On the prayer of Mr.
Tele, lordship.
G. Teddy, Learned Counsel for the petition, the case is passed over for the day. MS. Alorica, the Standing Counsel Revenue Department, and Mr. N. Goswami, Learned Junior Government Advocate for the state respondent are present.
May it please, your lordship. My lord, I have filed an IA, my lord. IA item number 46. What happened, my lord? Our house has been demolished, my lord. And the jute cultivation about the values more than 1 crore, my lord, has been destroyed by the government without giving us notice, as we are entitled to, my lord, under fair compensation, etc. acts, my lord. So, my lord, I filed this petition, my lord, just to get some interim relief, just some compensation, my lord, so that we can build our houses somewhere. my
We'll
lord.
try to take up if it reaches.
As, my lord,
Otherwise, we'll fix the date on a.
Lord, it is the 5th time and it is latest.
We'll
So, my
try.
lord, may I pray that before your lordship rising, last
We'll
item,
try.
as last item, my lord,
We'll see.
my lord, oblige your lordship.
My please, your lordship. I am praying for listing of the writ petition for admission, lordship. The subject matter is whether the Assam State Women Commission has a power to pass a order for the maintenance, lordship.
Make a prayer before the registry.
Lordship, I have already made a prayer to the registry, lordship.
Also, the matter before you go on fixing, it will be endless. Yes.
May I please, your lordship? Lordship, I am making this mention on behalf of Mr. P.K. Tiwari. Item number 28.
Yes.
I have taken the consent of the other side as well. It may be adjourned for a week.
Okay. Mr. R.J. Das, Learned Counsel, appearing for Mr. P.K. Tiwari, Learned Senior Counsel for the petitioner, has paid for listing of the case after a week.
After a week.
Also, it is submitted that consent has been taken from the Learned Standing Counsel ZHC to make the prayer. The prayer made by Mr. Das is allowed to list the case after a week on a date to be.
Deeply obliged. May it please, your lordship? I beg to mention for a listing of a case which was last posted on 8 November 2018.
Subject matter,
Subject matter land acquisition, lordship.
land acquisition.
Lordship.
What is the allegation?
It's a settlement of the land by the government, and where our land is out of the acquired without proper
Any interim order
property.
you are enjoying?
No, lordship. Any date next week, lordship.
No, like not next week.
Any date after next week, lordship.
Courtmaster will see to it.
My lord, I have one other matter. It was you lordship pass an order for fixed matter for passing interim order. Matter was listed, but not this on that day, my lord. So I made a prayer also before the rest. I also made a prayer, but not listed.
Okay, Mr.
On
Courtmaster will
Friday,
see.
my next Friday, my lord.
Yes.
May it please your lordship. Lordship, I'd like to mention for a listing of writ petition.
Motion.
Yes, sir. Yes, lordship.
Okay.
Lordship, any date next week?
Indian next week. Okay. Motion matter.
Yes, lordship.
So I have to mention one orders matter, lordship. Last it was left over on 7/2/2024.
Item number.
No, lordship, it was left over on 7/2/2024.
Orders matter.
Yes. Orders.
Side you.
Motion item number 1.
Lordship, we are alleging the violation of the order dated 11/4/23 passed in WBC 369 of 2023. Lordship will find the operative part at page 10, Lordship. May I read, Lordship? After considering the aforesaid facts and circumstances and also the written instruction which has been placed on record as forwarded by letter dated 16/23, this petition is disposed by directing the respondent authorities to consider the case of the petitioner and take steps to release the amount claimed in the petition towards professional fee as a counsel appearing for the department in the arbitration proceedings.
Mr. M. Das, learned counsel for the petition. To stop. The contribution has been preferred under so and so, read with so and so, alleging deliberate violation of an order dated 11/4/2023, passed in a writ petition, WPC number 369/2023. Issue notice. Reasonable in 4 weeks. The petitioner shall take steps for service of notice of the respondents by registered post PTAD within 2 working days. Obliged, Lordship.
Item number 2.
May it please your lordship. But this contempt petition has been filed alleging violation of order dated 8/2/2023, my lord. So you'll find the order at page 10. The relevant portion, page 15, my lord. Paragraph 7.
Compensation.
Yes, my lord. Jamindar's compensation, my lord, that has not been paid till date, my lord.
Heard. Mr. I.S. Vikia. Learned counsel for the petitioners. The contempt petition is filed under section 12. So and so, read with so and so. Rule so and so. Alleging deliberate violation of an order dated 8/2/2023, passed in a writ petition. WBC number 6279/2021. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice of the respondents by registered post PTAD within 2 working days.
Item number 4.
Nobody is present. Whether grievance has been redressed. Any water resource? Where is MS Ardeka?
She is on next.
What to do? I think we can dispose of this petition instead of keeping it with me. We'll call Ms. Ardeka. She was supposed to take instruction.
Item 6.
May I please your lordship? Lordship, in this case, actually, what happened actually, the private respondent number 5 had filed one check bounce case against me actually. In the CGM court actually, the case was filed on 10th of October 2023. Now what happened is that again she went on 31/2024 to the respondent number 3 and 4. Dispute PS. Now, what the police is doing is they are neither registering the case, but the thing is that they are calling me and they are only asking to come down. And when we say ki either you register the case or so that, so they are saying ki it is just an inquiry matter, you have to be here. So right now we are in the apprehension that if we go there, the case may be registered
Yes,
there.
Mr. Goswami, why they are calling without any case? If there is case,
Lordship.
yes, there can be someone maybe
Lordship.
under 41A, or he is a witness, he can be called. But
Yes.
unnecessary calling is a.
Not.
Take your instruction.
Oh. Okay, tomorrow,
Day after tomorrow.
definitely. Lordship.
Okay, Mr. S. Sharma.
I.S. Majumdar.
I have heard Mr.
I.S. Majumdar.
Learned Counsel for the Petition, and Mr. N. Goswami, Learned Junior Government Advocate, Assam for the respondent number 1, 2, 3, and 4. Full stop. Mr. Majumdar, Learned Counsel for the Petitioner, has submitted that the respondent number 4, 5, sorry, the petitioner,
Yeah, petition.
sorry, the respondent number 5 has instituted a complaint case under section 138 negotiable instrument
Negotiable instrument.
alleging in respect of alleged dishonor
Check one.
of a check amounting to rupees 1
1
lakh,
lakh.
and the said case has been registered,
Yes, yes.
and the said complaint
Yes.
has been registered as complaint case number
4177/2023
before the court of learned.
CGM.
Where is that?
Page 11.
Yes, 11.
In the court of learned Chief Judicial Magistrate, Kamrup within bracket Metro District, Guwahati. Post of the Mr. Majumdar has further submitted that on the pretext of a said complaint case, the respondent number 3, sorry, the respondent number 4 has been asking the petitioner to appear before him, without any case being registered against the petitioner. Full stop. The petitioner is under apprehension that if he appears before in the police station, there is every likelihood that he would be arrested without any case registered against him. So it is a submission that the petitioner cannot be called to the police station without due process of law. So Mr. N. Goswami, Mr. Goswami, Junior Government Advocate Assam, has sought for listing of the case on Friday, but in order to enable him in order to obtain instruction in this connection as regards the allegations of the petitioner, place the case as sought for by Mr. Goswami, place the case on Monday, sorry, Friday.
23.
Obliged.
I don't know, 7. May I please, Lordship?
Order actually.
Lordship, in this case, the petitioner was allotted a plot of land measuring 2 kotha 18 lesa.
Oh, yes, similar order.
Similar order, Lordship.
Issuing notice of motion. Mr. Goswami?
Lordship.
What is the area?
2
Of
kotha
land.
18 lesa.
Huh?
2 kotha 18 lesa.
2 kotha 18, let's say, 1 kotha. Overbury.
Lordship.
And mutation date was 21/9/1998. Mutation date.
Mutation date?
21/9/1998.
Okay. 20,
21/9/1998.
21/9,
Lordship.
1998.
98.
And what about 2 kotha?
18 lesa.
18 lessons.
Lordship.
Your name?
D. Borua.
G. Hazarika, 1 and 2.
1,
And Goswami,
3 to 7.
3 to 7.
Lordship, the matter relates to non-payment of ex gratia amount, my lord. The petitioner husband was died into February, my lord. On 25/2/2022, my lord.
When he died, date of death?
21/1/2020.
Okay, hard Mr. M. Overall. Learned counsel for a petition. Z. Hazarika. Learned standing counsel. Revenue. And disaster management department for the respondent number 1. Any ESMS finance, madam. RM Burwa. Learned counsel appearing for Mr. A. Chodika. Learned standing counsel finance department for the respondent number 2. And Goswami, learned junior government advocate Assam for the respondent number 3 to 7. Petitioner's husband, huh? Late Suraj Jamal, date of death 21/1/2020, ex gratia notification 14/11/2000, 15/11/2014.
15/11.
Huh? Huh? Ex gratia road traffic accident. Issue notice returnable for weeks as MS Hazarika, Borua, and Goswami. Extra copies, 2 working days.
Item
number 10.
May it please your lordship, kindly pass over the matter for time being.
Item 11.
Lordship, kindly pass over the matter for 10 minutes.
Item number 12. Sorry, 13.
Arguing counsel, Mr. H.K. Das is on the legs, Lordship, for number 1.
Item 14.
Where is the lordship?
But under my lord, Jal Jeevan Mission, my lord, a scheme namely Norasingapoti Mini PWSS scheme to provide drinking water to in respect of village Gusaigaon, Tongia, and Longkazan Old Village was sanctioned, my lord. But the public executive engineer, public health engineering, they are now going to implement the scheme in another village, Ambari village, my lord. So in this regard, the village has also approached the authority, my lord.
Where have you stated that it is sanctioned? Where is the document?
The document, my lord, from online petition has collect page 15, my lord.
Page
15, my lord. Left side, my lord, village name of the GP, Ambari, my lord.
Which serial number? Ambari, Jamuna.
My lord, it's at third. In Ambari village, GP, my lord, third number. Gusaigaon, Tongia village, Longkazan, Old N. That is the name of the village. The name of the scheme is, my lord, Norasingapoti, Tongia, FB.
Page 15.
15, my lord.
Okay, which
My lord,
row? Which row?
my lord.
What is your village? What is your village?
Village, my lord. Gusaigaon, Tongia village, Longkazan, Old N. In Ambari GP.
Ambari.
Ambari. Ambari village.
Norasingapati.
Norasingapati, yes, my lord. That is the name of the scheme, my lord.
Ah.
Village left side, my lord. Second column, Gusaigaon, Tongia village, Longkazan, Old N, my lord. 3 villages for to provide drinking water, my lord. But now some officials in negotiation with a private restaurant are going to divert the scheme to another village, my lord, Ambari village. while there is already a sanction scheme for Ambari village, my lord.
Yes, Mr. Gogoi.
Lordship, I will take the instruction in Lordship. Instruction, let it, short date may be fixed, Your Lordship.
My lord.
Heard Mr. B. Rahman, learned counsel for the petitioners, and Mr. R. Gogoi, learned standing counsel, Public Health Engineering Department,
President,
for all the respondents.
No, Your Lordship.
For
One,
the respondent number 1,
4 and
3,
5.
4, and 5, and Mr. S. Borwal, learned junior government advocate Assam, for the respondent
Two and
number 2.
2 and 3 also.
Okay. 2 and
3.
okay, 2 and 3. 1, 4 and 5, Aru, 2 and 3. The petitioners are residents, are inhabitants of village Tongia Gaon under Ambari Gaon Panchayat, district Pujai. According to the petitioner, a drinking water scheme was under the Jal Jeevan Mission, was sanctioned for installation for Ambari Gaon Panchayat, and the same
My lord, sanction for 3 villages, Gusaigaon, Tongia, and
Ambari Gaon Panchayat
Under.
and for covering the areas falling within the villages, that's Gukaigaon, Tongia, and Lonkajan Old N. The petitioner's allegation is that the respondent authorities in the PHE is contemplating to shift the installation of the said drinking water scheme at a place outside Barigaon Panchayat. So Mr. Gogoi, learned standing counsel, PHE department, has sought for 7 days, a week's time.
Week's time, my lord.
Huh?
A week's
Week's time to obtain instruction as regards any decision to shift the water supply scheme from the Ambari Gaon Panchayat or not.
Well, they are also trying to shift it within Ambari Gaon Panchayat to another village, my lord.
Okay.
Otherwise, they
To another village. It is maybe a feasibility,
Most probably.
maybe a feasibility issue. Okay. Or beyond no. To another village within Ambari Gaon Panchayat. R. Gogoi, 1 week's time to obtain instruction as regards any decision of shifting the water supply scheme from the earlier place to another place within Ambari Gaon Panchayat. Place the case on
Very well.
1 3.
Obligation.
Item number 15.
Please, your lordship. Lordship, in this matter, petitioner filed an FIR, lordship, on 18/8/2023, lordship. The office in Sir Tizpur Police
In the
Station.
direct provision just to register of investigation stated in the So why you are aggravating before this court? Agitating this issue before this court when the special judicial magistrate has the authority and jurisdiction to decide the issue? Why?
My lordship, I am unmarried daughter of my widowed mother, my lordship.
Right now,
Thereafter-
the question you have raised here,
Yes, my lord.
that initially FIR was not raised.
Yes,
You filed a complaint.
yes, my lordship.
Magistrate forwarded the matter
Then
for
also
investigation-
affair is not even
for
registered.
investigation under 156(3),
Yes, my lord.
right? So case has been raised.
No, no, my lordship. After that also not registered. Then I filed representation before the commissioner. Then also not registered. I have CCTV footage, my lordship. They came, they ransacked my house and stolen.
Mr. Loskar,
Yes, my lordship.
you have said in the synopsis,
No.
order dated 27/10/2023. Please come to that only.
Yes, my lordship. I filed a fire.
Please come to that 27/10/2023.
Yes, my lord.
That's all.
2710,
Show me the
page 33. Page 33.
So thereafter,
No, nothing has been registered. The case has not
then
been.
why you have come before this court? Why you have not approached the special judicial magistrate, Assam? What is the reason?
Thereafter also I filed representation before the commissioner.
No, no. After the court has directed
Yes, my lord.
registration of the case,
Yes, my lord.
it is for that court to look out whether FIR has been registered or not. He can direct everybody, SP to commissioner, everybody. Why the case has not been registered? This is not the forum, Mr. Loskar. Just a drop of a hat, you will come running to the High Court. What the Supreme Court has held in such cases,
My lord.
it should be thrown out.
My lord, already I have filed 156(3) already filed petition.
Let us see your pleading after 27/10/2023. Did you approach the magistrate?
No.
Have you stated anything that you have filed some petition? Enough on the order. No, absolutely silent. Yes, Mr. Borua.
Yes, Lordship was right. Page 27 makes it very clear, investigation is to be done, FIR to be lodged. If at all he's aggrieved, he could have approached.
Yes, that authority can very well take care of disobedience in its own order if a case is not registered.
If judicial magistrate is in seize of the matter.
Yes. Page 33.
33. Makes it very clear. Directed the registry or to register a file, investigate into the same and either by himself or
Hard.
through assembly.
Mr. S.B. Lost. Learned counsel for the petitioners. And Mr. S. Borua, learned junior government advocate Assam for all the respondents. Para. The petitioners have sought to invoke the extraordinary jurisdiction of this court under Article 226 of the Constitution of India, seeking a direction in the nature of mandamus to the officer in charge, Dispur Police Station, to register a case on the basis of a complaint filed by the petition number 2 in terms of an order dated 27/10/2023, passed in CR case number 588/2023, passed by the learned special judicial magistrate, first class, Kamrup Metro. What are the relation between two petitioners?
Yes, sisters, my lordship.
The two petitioners are sisters in relation. And according to them, the petitioner number 1 is in occupancy of a government actionia land. Which was possession of which was handed over to her by her stepfather, late Ahidur Rahman, who died on 3/10/2020. The dispute arose between the petitioners, petitioner number 1 and another person in respect of the said plot of land. And the dispute led the petitioner number 1 to submit an application before the circle officer, before the respondent number 3. No, before the circle officer, dispute revenue circle for cancellation of annual patta issued in favor of the other person.
No, my lordship.
That is what your paragraph 4 says.
No, my lordship. The fact of the matter is that the government law patta holder was some other person.
It is the allegation of the petitioners that the petition number 1 filed a first information report before the officer in charge, Dispur Police Station, on 18/8/2023, alleging commission of offenses, cognizable offenses. Full stop. When the petitioner, when the officer in charge, Dispur Police Station, did not register any case on the basis of the said FIR, the petitioner are stated to have approached the Commissioner of Police, Guwahati by way of a representation. When the representation stated to have been submitted before the Commissioner of Police, Guwahati, did not evoke any response, the petitioners approached the Court of Learned Chief Judicial Magistrate, Kamrup Metro, Guwahati, by way of a complaint Full stop. On receipt of the complaint, the same was registered as CR case number 588. Proxy. Stroke 2023. Full stop. Para. The same complaint case, CR case number 588C, stroke 2023, to transferred to the Court of Law and Special Judicial Magistrate First Class Kamrup Metro. After going to the affidavit submitted by the complainant, that is the petition number 1.
Yes, my lordship. Petition number, complaint was filed by petitioner number 2, my lordship. The sister.
And upon hearing the learned counsel for the complainant, the learned special judicial magistrate, first class, found that there was need for police investigation in respect of the allegations made in the complaint. Full stop, accordingly, the learned special judicial magistrate first class Kamrup Metro Guwahati, by its order dated 27/10/2023, directed the officer in charge, Dispur Police Station, to register a first information report and thereafter, to investigate into the scene either by himself or through a subordinate officer, and to submit a report in final form. The said order dated 27/10/2023 is evidently an order passed in exercise of the powers conferred under section 156 within bracket 3 of the Criminal Procedure Code 1973. The petitioners have approached this court by the instant writ petition with a grievance that despite the order dated 27/10/2023, the officer in charge, Dispur Police Station, has not registered the first information. The position of law in this regard is settled. First off, it has been observed by the Honorable Supreme Court of India in Sakiri Basu versus State of Uttar Pradesh and others, reported in 2008 to SSC 409, that if a person has a grievance, that proper investigation has observed that para 15, section 156(3) has provided for a check by the magistrate on the police performing its duties under chapter Roman 12, CRPC. In cases where the magistrate finds that the police has not done its duty of investigating, has not done its duty of investigating the case at all, comma, or has not done it satisfactorily, comma, he can issue a direction to the police to do the investigation properly, comma, and can monitor the same. Full stop. A judicial magistrate, before taking cognizance of the offence, mentioned in a complaint, comma, can order investigation under section 153(6)(3) CRBC. It is settled that even if a magistrate does not say in so many words, while directing investigation under section 156 within bracket 3 CRPC, that an FIR should be registered, comma, it is the duty of the officer in charge of the police station to register the FIR regarding the cognizable offence. Disclosed by the complainant, because the police officer could take further steps contemplated in chapter 12 of the code only thereafter. Full stop. It has been held that there is an implied power, paragraph 24, in a magistrate under section 156(3) CRPC to order registration of a criminal offence and or to direct the officer in charge of the police station concerned to hold a proper investigation and take all such necessary steps that may be necessary for ensuring a proper investigation, including monitoring the same. Para. In this connection, it is also apt to refer to the following observations made by the Honorable Supreme Court of India in Sudhir Bhaskar Rao Tambe. Hemant Yasman Thaki, no? Yeah, I got it. Para. In view of such settled position of law, comma, this court, while not entering the present writ petition, comma, observes that the petitioner shall avail the remedy by approaching the jurisdictional magistrate under section 156(3) CRPC. If, despite the order dated 27/10/2023, the officer in charge, the concerned officer in charge, the officer in charge of the concerned police station has not yet registered a case. And if the petitioner approaches the jurisdictional magistrate under section 153(6)(3) CRPC, the jurisdictional magistrate shall ensure that the case is registered and if prima facie he is satisfied, a proper investigation in the matter, and if required, shall also monitor the investigation. First off, it is further observed that if the jurisdictional magistrate deems it necessary, he can also recommend to the concerned superintendent of police a change of the investigating officer so that a proper investigation is done. First off, the petitioner is at liberty to produce any supporting materials with regard to the claim that no case has been registered by the officer in charge of the police station, despite the order dated 27/10/2020.
Highly obliged, my lordship.
Item number 16.
May it please, your lordship. It was by this application, my lord.
Bit louder.
By this application, my lord, I have challenged the input order.
Tara Mia, yes.
Yes.
Who is he?
Well, he is subsequently selected as the chairman after removal of the earlier chairman. That is the respondent number 6 from the post of Kukurmara Samabay Samiti.
Which society?
Kukurmara Samabay Samiti.
Kukurmara Samabay Committee. Okay.
But
South
what had
Palmyra
happened?
Mankasi. Okay.
Yes. The earlier chairman, that is the respondent number 6, who was removed from the post by way of no confidence motion and pursuant to the resolution dated 27/9/2023, which is at page 24, my lord.
Page 24.
Out of the 15 members, my lord, the 13 members have
board of are present, discuss no confidence against chairman.
Chairman.
Who is the chairman?
Chairman, that is respondent number 6, my lord.
He was present there.
My lord?
He was present.
No.
Kukurmara are present.
Despite his knowledge regarding
no
the meeting.
confidence against the chairman of the name Abdul Subud. He was the chairman of the chairman of the society. Departmental observer.
Yes.
He was present.
He was present.
Majority member proved that no confidence motion against the
Then, my lord, the respondent number 6 filed an appeal before the Registrar of Cooperative Societies, Assam, my lord. The appeal is at page 28. Against his removal.
Mr. Taluda, just for my query, in such situation, appeal is maintainable.
Yeah, there is a provision, my lord. Provision.
Provision.
36, 36(5).
Let us.
36(5) is there.
Okay, appeal under 36.
Yes.
Just sound. What is the allegation there in the appeal?
My lord?
What is the allegation there?
His allegation that he has no knowledge about the holding of the meeting, my lord. That is the main allegation he has brought, my lord.
Seat
And-
being
and-
held on so and so in presence of the observer appointed by the doctor. I was kept at dark regarding the special meeting. I only came to know about the meeting when the office bearer visited my 36.5.
Yes. Page 34, my lord, of the.
Okay. Okay.
Then, my lord, this appeal referred to the Assistant Registrar of Cooperative Society to cause an inquiry into the matter, my lord. The letter of the registrar, page 31. my lord.
Hmm. Yes.
Then the Assistant Registrar of Cooperative Society directed to cause an inquiry into the appeal petition of the respondent number 6, my lord, to the Sub-Registrar of Cooperative Societies and one senior inspector.
Okay,
of
he
the-
again forwarded.
Yes.
Ah.
Again forwarded. Then the inquiry was conducted and the report is at page 33, my lord. The joint report has been submitted.
What is the sum and substance?
Sum and substance, my lord, in the from the bottom, my lord, the second paragraph. As per office record of ARCS Hatchingmary, a letter by number so and so dated so and so was issued to the chairman secretary of the Kukurmara Assets Limited that Sri Horeram Roy, senior inspector of Cooperative Society Hatchingmary, was deputed to inquire the activities of the BOD meeting to be held on.
Okay, this paragraph, that sir, BOD of Kukurmara Assets Limited is now divided.
Yes. But after passing the no confidence motion.
That is the story.
That is
Now
this
divided.
now divided.
Then
Well, the ARCS has disposed of his appeal as per the direction of the
what is this page? Annexer 7 page?
Annexer 7
35?
35, my lord.
Ah.
This is the order passed by the ARCS, whereby dispose of the appeal petition filed by the respondent number 6.
It
And
suffers on two counts, and assistant registrar cannot dispose of. This is one.
What?
Secondly, shifting allegiance to the other party later on.
That cannot be.
That cannot be. Both are primary.
But
ex specie.
yes.
There is.
Then what what happened thereafter? Okay, this order. Page 53.
Yes, page 50. Page 51 is the impugned order, my lord. Wherein also, my lord, basic ground has taken that subsequently, after passing the no confidence motion, some members
Hearing was
have
attended by on hearing. As joint petition withdrawing. After voting, how can
cannot be, my lord.
then petitioner should be removed? Then again, he should be resolved.
Yes.
That should be the process. After voting or
The entire things proceeded, my lord, in an erroneous way.
Yes.
He could not have delegated because the act says, my lord, it is the register.
register.
So that delegation
That
of.
is one.
Yes.
Secondly, in the no confidence motion, the meeting where the no confidence was discussed,
Yes.
they unanimously passed a resolution.
Yes.
That ends there.
That is
Yes.
that attain finality.
Yes.
And the register, that is, my lord, I am fairly submitting. The register could not have said that now 7 members
Yes.
has withdrawn it.
No,
That is
that's-
also not permissible, my lord.
That is,
Yes.
yes, they can say,
Yes.
but then
My lord,
they
that-
have to remove.
Yes.
If there is no bar under the law to reinstall Abdul Subur
Yes.
again as a chairman of the board,
Yes.
by vote it can be.
Yes.
But
My lord, what I'm trying to say, in fact, if your lordship sees the order, page 51, what the registrar had done, my lord, he had decided, my lord, my lord, in fact, he has taken it as an appeal against the order of the ARCS. And perhaps, my lord, he has exercised 111. This could not have been done in view of the fact, my lord, that there is a provision, specific provision under 36(5). So at best, my lord, an appeal lies under 36(5) directly to the register. And register could have considered whether this can be a ground for allowing the appeal or
Yes.
considering the appeal. That second members have withdrawn.
because see, these other
Please.
petitioners or other respondents maybe, who prefer the appeal?
Is respondent number 6.
6. He was correct in preferring. See page 28.
No, my lord, yeah, that is
So
correct.
he was correct in preferring.
Yes, correctly.
36.5.
Yes, that
But
is correct.
see the register's
Yes.
action,
That is wrong, my lord.
page 31.
That is wrong.
Request you to inquire into the matter and dispose of the same.
That could not have been done. He has delegated the power under 36.5.
Heard, Mr. R. Islam, learned counsel for the petitioner, and Mr. S. K. Talukdar, learned standing counsel.
Lordship will not record it, my lord. I'm just fairly submitting. Otherwise, it will go against me, my lord.
Cooperation Department for the respondent number 1, 2, 3, 4.
My lord, 1, 2, 3, 4, my lord.
4. Full stop. It is the case of the petitioner. You are a board member.
Yes, well, subsequently I have been selected.
You are a board member.
Yes, board
Otherwise,
Yes, otherwise I am a board.
Elected board member.
Elected board.
comma. A elected director in the board of directors of Messrs. Upurmara Homobai Committee Limited within bracket of society, comma, a cooperative society registered under the Provincial Assam Cooperative Society Act 2007, comma, that in a meeting convened on 27/9/2023 to discuss a motion of no confidence against the then chairman of the society, V.I.Z. Abdul Subur, within bracket the respondent number 6. The said motion was unanimously passed against the respondent number 6, comma, in presence of a departmental observer. Poster. Agreed by the resolution passed in the meeting, comma, held on 27/9/2023, comma, the respondent number 6 had preferred an appeal under section 36 within bracket 5 of the Act Koima Act. Full stop. On receipt of on presentation of the appeal under section 36(5) of the Act, comma, the Registrar of Cooperative Societies, Assam, when you get the response number 2, forwarded the memorandum of appeal to the Assistant Registrar of Cooperative Societies, Hatsing Mari, within bracket the response number 4, to inquire into the matter and to dispose of the same with intimation to him. Full stop. The respondent number 4 had thereafter caused an inquiry through his subordinate officials who who submitted an inquiry report dated 23/11/2023 before the respondent number 4. Full stop. Reporting inter alia that the directors in the board of directors of the society has subsequently divided into two groups. That's 8 numbers in favor of 8 numbers against the respondent number 6 and 8 BOD members. Well, plus 8 directors in the BOD against the respondent number 6 and 7 directors in the BOD of the society, including the respondent number 6. On the other side, full stop. Based on such findings, in the inquiry report, what did he do? The respondent number 4. What did he do?
Last page, my lord, page 37.
37, what did he do?
Under the above stated facts and circumstances, it is very clear that majority of BOD members of your society are not agree to run the society under your chairmanship, that is for respondent number 6. And hence the resolution adopted so and so 13 board of members is kept still in force.
Oh, he was in favor.
My lord.
This register of cooperative societies, he was in favor of the resolution.
Yes, in favor of the resolution.
The respondent number 4 had observed that the resolution adopted by the board of directors of the society, by 13 number of board of directors of the society, in a meeting, held on 27/9/2023, was valid. Full stop.
Then page 38, my lord.
The respondent number 2 has thereafter passed an order on 21/12/2023. After hearing few of the stakeholders, by the said order, by the said impugn order, in the said impugn order, the respondent number 2 has observed that eight number of BOD members of the society had submitted a joint petition withdrawing the no confidence motion against the respondent number 6. Full stop. Observing that the majority of directors in the board of directors of the society had agreed to continue the respondent number 6 as the chairman of the society chairman of the board, chairman the board of directors of the society by withdrawing their resolution passed earlier on 27/9/2023, the respondent number 4 has held the motion, the resolution of or resolution, sorry, the motion of no confidence passed against respondent number 6 to be invalid. Full stop. Mr.
No, that should go as respondent 2. It has gone as respondent 4. That should go as respondent 2.
Respondent number 2.
Yes.
It will respond 2, huh? Last one. Agor can you respond 4? It has been contended by the learned counsel for the petitioner that the resolution against the respondent number 6 in the meeting held on 27/9/2023. Sorry. Neither respondent number 4, neither the respondent number 2, nor the respondent number 4 has held the proceedings and the resolutions expressing want of confidence in the respondent number 6 in the meeting held on 27/9/2023, as invalid. Full stop. Even if majority of the board members have purportedly changed their positions, showing allegiance to the respondent number 6, the same could not have vested the respondent number 4 to hold the power, authority, and jurisdiction to hold the no confidence motion passed unanimously against the respondent number 6 on 27/9/2023 as invalid. Issue notice as Mr. Taluga 1 to 4, no formal notice, extra copies within 2 working days. The petitioner shall take state for service of notice upon the respondent number 5 and the respondent number 6. I read that both clearly. Having regard to the projections made, this court is of the considered view. I can look it. Accordingly, this court is of the view that a interim relief is called for, and accordingly, the impugn order dated 21/12/2023 shall remain state until further orders.
Master.
4 weeks. Until further orders, interim orders statement.
No, 17.
May it please your Lordship. The subject matter of challenge in this writ petition is an order of suspension and initiation of a disciplinary proceeding. The petitioner, he is an employee of the MSCT Dhubri. For a medical emergency, he applied for 4 days casual leave. and left for Guwahati for treatment of his child and wife also. Then immediately on the same day, he was informed that the leave, casual leave has not been sanctioned, so he has to resume his duties. So he came back, he was supposed to join on 10th of March, he came back and on 9th of March he has joined. Immediately after receipt of receiving this, the joining, resuming, a show cause notice was issued to him why disciplinary proceedings should not be initiated against him for unauthorized leaving the headquarters when the leave was not sanctioned. He had shown cause. He has given a detailed reply supported by medical documents. Thereafter, he was placed under suspension and the proceeding has been initiated, and the charge is that you were unauthorizedly absent, your leave was not granted.
Mr. Das, what is the procedure of applying for casual leave?
He has to submit an application.
It is for sudden
document.
emergency also.
Yes.
It is not that you will wait till, like a person met with an accident on the road.
No, that's
Instead
true.
of taking him to the hospital, whether that person will go to lodge an FIR before the police station.
No, had, my lord.
No, what is the procedure of making a, what is
Even
the purpose of casual leave?
So that if an emergency situation arises,
Ah.
even, there are instances wherein person did not go to duty and thereafter submitted an application.
Show me and take the instruction, proper instruction. Because if it is, it can be post leave also sometime.
Yes.
But,
Because of sudden emergency, the purpose is basically casual leave means it can occur suddenly.
Yes, yes.
All right. If suppose, we don't know about the medical, but emergency, whatever. But suppose you are supposed to submit an application, but because of certain emergency, he did not submit. Say, in the later part of the day, he submit. Then, whether this is a case of misconduct.
That emergency has to be there, my lord.
Uh-huh.
But his own application, so far as I could gather, my lord, he submitted an application saying that I shall go to Guwahati on account at some urgent work as well as medical checkup of my wife.
And baby.
And
the baby.
yes, and my baby. And the case that has been projected in page 18. And the
Page 18.
case that has been
I have the
projected
honor
before-
to state that I shall go to Guwahati on account of some urgent work as well as medical checkup for which casually.
He is a chief.
Whether it
District
primarily indicates a case of misconduct, because I don't know about the casual leave. I have never
Not the only
had the
casual leave.
occasion
Uh,
to examine the purpose of casual leave, the manner in which a casual leave is to be applied. Show me. Because otherwise,
because
it may happen that it is a misconduct on the part of the disciplinary authority.
the case that has been sought to be projected before your lordships is that the son, he suffered from some serious urinary.
No, we are
infection.
on the casual leave first.
Fine.
We are on the casual leave. Suppose a person makes an application that I want to go on a casual leave for a day or 2 days. At a stage, how much days can be availed? Casual leave, right? And when it is to be applied? Because this is for sudden emergency. We are not into the veracity of the ground right now. We want to know what is the casual purpose of casual leave and how it is to be applied.
I'll apprise your lordships on that.
With the
And
basis of notification or whatever extent
Yes.
rules is there,
leave rule is there.
whatever extent rule, that is it mandatory that one has to file the application before going for casual leave?
And he has filed. He has.
I have given the example just there that one has suffered head injury. The person has to be taken to the hospital or to the police
Yes,
station.
yes. Hospital.
Then
That's
whether one has to make a application for casual leave or He has to attend the urgent situation.
That urgency.
Early,
always-
I know, early that can be. But these are for sudden situations.
Urgency has, if there is urgency, my lord, definitely there is no requirement.
Urgency is one thing, but what the manner, at what time the casual application for casual leave is to be submitted? Is it necessary before going on casual leave or before station leave? Is it a case of misconduct? First, you apprised me with,
Yes.
with page 19 application.
Yes, my lord. And
Right.
so
It was received at 10:49 AM.
yes,
If the endorsement is correct,
yes,
at page 19, it was received at 10:49.
Yes.
10:49.
And
AM.
mail was sent at 10 o'clock,
10 o'clock.
And he submitted it and he left. But if your lordship,
If the authority does not, suppose, allow the casual leave, early, I know. But casual leave, not granting of casual leave.
my lord, subject to correction, my lord, leave is always at the discretion, that is one aspect of the matter.
Discretion.
Nobody can claim. Now that discretion
Show me
should
that,
not
show
be,
me that casual leave, the manner for filing an application for casual leave.
I'll come up with that. But so
Huh?
far as the disciplinary proceeding is concerned, show cause notice, it doesn't only contain this allegation of, my lord, remaining absent. There are other allegations also.
What is it?
Possible, have a look.
It makes a very interesting reading. My lord. Your lordship will kindly see the show cause notice.
Page 33.
Thirty-two. 33 is the articles of charge.
Relevant.
Everything revolves around that absence of 3 days.
Not only unauthorized absence.
Twelve articles have been framed for that 3 days absence.
You want leave for a particular purpose, tell the truth that for this purpose I want leave.
That is what is done.
Say,
Para 34, third paragraph. This kind of allegation, without any statement of allegation, let the statement of imputation, let us see that is it a SARS?
statement is, yes.
That instigation.
Filing a worker no iniquities, querying the respondent.
Or 1 minute. Twelve charges. 12.
My lord, many of the charges are identical, my lord.
Yes, sir.
Incidental to one another.
Where is the instigation part?
Instigation charge,
Because page 34, third paragraph.
yes.
Various acts of indiscipline, insubordination by not following official orders have instigated the other subordinate staff to commit similar acts of insubordination and thereby has created an unhealthy working environment in the MSCT Dubri. Where is the charge
I'll just check.
connected with?
Article 11.
Article 11.
Because there were previous.
Well,
instances
various
also
acts
somewhere.
have instigated. Similar acts of subordination has created. Where is that? Connected document.
Connected document.
Mr. Das, please show me the details about casual leave applications and procedures. That I
Lordship.
think before proceeding further, because it appears something more than meets the eye.
But one aspect
Show
is
me the
there.
procedure. I'm not
I'll-
saying anything this way or that way.
Fine, fine, my lord.
The
I'll,
procedure exactly what is in the rules.
from the leave rules, my lord. yes.
Leave rules, no. What is the application in respect of leave rules for state government, whether these are applicable and regarding
Casual leave, is there any
that-
office
that-
memorandum?
That will not be available in the leave rules perhaps. But there are some office
Yes,
procedure.
office memorandum, yes. I'll
Office
come up.
memorandum, that should be placed. Day after tomorrow,
Fine. my lord.
Let it be on Friday, my lord.
Friday.
On
But-
Monday, Lord.
Lay everything before this court.
Yes, yes, my lord.
Please lay everything.
Yes, yes. my lord. Whatever, as an officer of the court, whatever I
officer
could
of-
gather, my lord, I'll place.
As an-
Whatever manner it goes, I am not.
As an
concerned.
officer of the court.
Right.
Because you are nor for the petitioner nor for the respondent.
Yes,
Receiving
my
of
lord.
court.
Yes,
We have to see that the rule of law should prevail.
yes, yes, definitely.
That's all. Right, Mr.
Monday, Lord.
Mr.
Monday.
N.K. Chaudhary, learned senior counsel, Assistant by Mr. T. Bhardwaj, learned counsel for the petitioner, Mr. H.K. Das, learned standing counsel, GHC.
Respond number 1, 2, 3.
For the respondent,
1, 2, and 3.
number 1, 2, and 3. Mr. Das, learned standing counsel, GHC, shall place before the court the procedure for application of casual leave and grant of casual leave. The extant, EXTANT.
My lord, my only worry is that before your lordship, the instruction is received, he may in the meantime be punished, my lord, penalized in disciplinary proceeding.
Not penalty.
We will
DP has
see
to
that,
be-
we will see to that. Let- okay, good.
Monday, Lordship will kindly take it
Friday?
Monday. I'll get some reading time.
50 meter,
Yeah.
only 50 meter from this
Yes.
spot. Right?
Fine, fine,
Not from Thuri or somewhere.
fine.
Obliged.
Deeply.
Item number 18.
Against the eviction notice, my lord.
Eviction
I
notice,
input notice, my lord, page 15, your lordship sheet, my lord.
page 50.
15. And eviction notice are issued by circular officer, my lord. Actually, my lord, circular, whether circular officer can issue eviction notice, my lord.
That ground is no longer available.
Under section, my lord, 1801, my lord, as per.
That has
regulation,
been
my lord.
empowered notification
Yes,
from Assistant Circle officer. Do you have the notification? He has been amended. Circle officer.
Circular,
এই
but it is not a very circular.
ডাঙৰ কিতাপখন, এই ডাঙৰ
Revenue circle.
আসাম লেণ্ড এণ্ড ৰেভিনিউ মেনুৱেল এই গ্ৰীণখনো দিব খুজিব because here one provision is not available, right? In this book one provision is not available.
Yes, my lord.
Mr. Here it is available, but settlement rules. Settlement rules 18, right?
Lord, for that, no enforcement case number, but nothing of this.
1
sort.
minute. Rules.
Yeah, my lord.
There,
Yes, my lord.
in settlement rules, rule 3,
Settlement rules.
rule 3, sub rule 2. Now that rule has now included circle officer also. By way of an amendment in
Right.
2010. So that ground is not available.
That agree, my lord. Your
Okay.
lordship, see, my lord.
Now next
There is-
ground, next ground.
Yes, my lord. 1 page 1 5, my lord.
One page 1 4. 14 is the notice.
My lord. That is, my lord, actually, that apart from this, my lord, it is, my lord, as per this,
this is
1937, my lord, the land is under the position of the, my lord, the petitioners, my lord, or lease. The one, my lord.
No, he has asked for a hearing only. Page 14.
Which one?
14.
Yes.
Then thereafter, page 16.
The second notice.
Second notice.
Second notice, my lord. This is the notice, eviction notice. In the first notice, I appeared, my lord, or the office, my lord, but officer was not present. I am ready to, my lord.
That was in May 2023.
My lord.
No urgency then. They have not been dispossessed. Oh, now.
My lord.
Okay, now. Oh, why did you not challenge this page 16 at that point of time? Page 16.
That was issued by 22nd, my lord.
22nd May 2023.
I was given time up to 29, 15, my lord. Only 7 days time was given to me, my lord.
Why he did not challenge at that point of time?
So I could not, my lord, challenge that one. Thereafter, I get another notice, my lord.
That is after 7 months. Eviction notice was on 22/5/2023.
Yes.
You waited for 7 months.
Well,
Then this
yes,
page
my
21 notice was served.
124/5, I filed an application before a deputy commissioner, my lord. That is, your lordship, Annexure C, my lord.
Okay.
That was pending before this court, my lord, before the deputy commissioner, my lord. Annexure C, my lord. Page 17. I filed an application before the deputy commissioner, my lord. That was also pending till today, my lord.
And what is your claim? Basically, you are government land. That is what 9 bigha, 2 katha, 9
Yes,
6 lessa.
Then we were 5 family was there, my lord, which our homestead, my lord. Since
Then
1937,
9
my lord.
bigha, 2 katha, 6 lessa.
Yes, my lord.
Now, what is your in support of your claim? As regards that document.
Yes, my lord, I am the.
Oh, nothing.
I am possessing your lordship.
There is nothing.
Nothing. I am possessing the land since
Doji
97.
Bahira. Doji Bahira.
That is my exclusive.
Doji Bahira revenue. Bedokoli Jonimona, is it available?
That is my lord, on the lease. I have land was taken from Goswami, my lord. I have transaction with
Mr.
him, my lord, for money
Mohammed,
transfer there, my
you have not annexed not a single document in support of your claim. This court is not in a position to help you.
I will my support document, my lord. Let me have some time, my lord, because my lord.
And counsel for the petition. Mr. MS N Board, and it's spending out the revenue. Department for the respondent number 1 and Mr. S. Burwa. Planet Junior Government Advocate Assam for respondent number 2, 3, and 4. Full stop. Assailing 2 notices. Dated 22/5/2023. annexer within bracket B and dated 28/12/2022 within bracket annexer D. The petitioners have preferred this petition. Issue notice returnable in 4 weeks as well.
In fact, Lordship, in his representation, he also refers to another notice which is 11.5 that is not on record.
11 for which one?
Page 17. So
Page 17.
Yes, page 17. He refers to one notice. I don't know what exactly it is. Page 17, the first part.
This is my application.
We get a notice on 11.5 from the
Page 17.
Page 17.
11,
The translated copy of his application to the Deputy Commissioner.
On that day, I was directed to appear.
So this is said to be a notice.
11.5. Perhaps page 14. সেয়েহে অহা 11/5/2023 তাৰিখে ৰাতিপুৱা 11 বজাত এক শুনানি গ্ৰহণ কৰা হ'ব। I think after that 11/5/2023.
It is a date, but he has referred to be as a notice that he has received on 11.5.
And that was thereafter, perhaps. Thereafter this notice, page 16. But you have no document to substantiate.
No document. In fact,
Your Lordship, the document I will.
the first hearing was called for.
Before Lordship, I will put the document. But at this stage, my Lordship, is a considered matter, my Lord. I am posing the land since my 1937.
You should notice it. You can't help it. You have no document. Not a single document.
First hearing was called for to come with document. Item 19.
We appeal the Lordship. The petition has been filed against the tardy investigation that has been carried out by the police, Your Lordship, against an FIR that was lodged at 12/5/2022.
Did you file any subsequent application or not?
After this application before
Under
that.
156.3. Let us see 156.3.
Lordship,
Where is that?
to page 39, annexure D, the order that has been passed by the additional CGM, Your Lordship.
Now, after this order, what grievance you have?
The only thing is that, your lordship, based on this purported agreement for sale, your lordship, the accused person has been claiming the sale process of this purported agreement for sale. And police has, nothing has been forthcoming from the police yet, your lordship.
Then did you approach again to
No,
the
your
chief magistrate?
No, your lordship.
Huh?
After that, nothing, your lordship.
Then you should approach.
Because this was the only remedy which has been exhausted, your lordship. So
No, that under that he has the power to
only the
monitor
monitoring
investigation.
Only the monitoring part was not there, your lordship.
So he should monitor. If he is privacy satisfied that investigation is not proceeded or progressed properly, if he is satisfied, if you are able to convince,
Right, your-
we are not here
right, your lordship.
to monitor investigation. He is the person.
Yes, your lordship.
Law is settled.
Yes, your lordship. Agree.
It is not a case of such a heinous character that it should be entrusted to CBI.
Certainly.
I don't think so. It is a case of under section 420, 406, 471 only.
Yes, sir.
Using false document as genuine, criminal breach of trust and cheating for the purpose of. I think you should approach, we can observe only that.
That observation may be right, your lordship.
Order to have. থাকি বছর রহিল আৰু এই আগৰ যে মাত্ৰ অৰ্ডাৰটো পাইছিলে ফলবিটা আছে নেকি ওকে ওয়েলকাম
Yes.
J. Ahmed. Learned counsel for the petition. Miss S. Borua, learned junior government advocate Assam. For all the respondents. Full stop. The petitioner has approached this court by this writ petition. By instituting this writ, seeking to invoke the extraordinary jurisdiction of this court under Article 226 seeking to invoke the extraordinary jurisdiction under Article 226 of the Constitution of India. Alleging with a grievance that despite registration of a crime case, Sangsari police station case number 198/2022 on the basis of a first information report lodged by the petitioner, the investigating authorities, the investigating officer of the case has not shown has proceeded with a lackadaisical investigation in the matter. Full stop. It is that the case projected by the petitioner, is that the petitioner, along with her son, are joint pattadars of a plot of land measuring 3 bighas, covered by tag numbers 887, 946, 947, and KP Patta number 457, situate at village Korol, Moja Ramthurani, district Kamrup, Assam, the subject court. the petitioner's son is a resident of Canada and got married in the, she is the accused,
Yes, Your Lordship.
got married with a lady, who is the accused in Sangsari Police Station case number 198/2022, on 22/02/2012. Full stop. In course of time, the petitioner and the accused got separated in the year 2016. Full stop. Litigations ensued thereafter. Litigation as regards separation, stroke, divorce, stroke, custody ensued thereafter between the between the petitioner's son and his estranged wife in courts of Canada. It is the allegation of the petitioner that the accused submitted and allegedly forged deed of agreement for sale in respect of the subject plot, stating that the said agreement for sale of land was executed by the petitioner and the petitioner's son in December 2019. In respect of the said allegedly forged agreement for sale of land in respect of the subject plot, the petitioner's son lodged a first information report on 12/3/2022 before the North Guwahati outpost, and the said FIR stood registered as Sangsari Police Station case number 198/2022 within bracket for offences under sections 420, 406, 471, Indian Penal Code. The petitioner at an earlier point of time, alleging lackadaisical investigation in respect of Sangsari on the part of the investigating officer in connection with Sangsari Police Station case number 198/2022, approached the court of Planet, Chief Judicial Magistrate Kamrup at Aminggaon by filing a complaint under section 156(3), Code of Criminal Procedure 1973. Full stop. On the basis of the said complaint, comma, the learned additional chief judicial magistrate Kamrup at Aminggaon White order dated 25/4/2023.
Page 39.
Page
39.
39. After producing a status report as regards investigation. After producing a status report submitted by the IO on 12/5/2023, comma, directed the IO to expedite further investigation. Full stop. Para. The petitioner has approached this court with the grievance that despite the order dated 25/4/2023 of the learned additional chief judicial magistrate Kamrup Aminggaon, comma, the investigating officer has not expedited the investigation and the subsequent, I'm sorry, and the manner of investigation has given rise to a serious doubt in the mind of the petitioner that the investigation is not being carried out in a fair, proper, and impartial manner. Full stop. It is the allegation of the petitioner that the investigating officer has not taken proper steps as regards the alleged forced agreement for sale of land and to arrest the persons who has sorry, alleged the accused persons. Fair enough. I got to leave. I got to follow with yes. I've already passed an order.
Yes, Your Lordship.
Same order. In item, I think item just now we have passed it. Item 15. You approach along with all the supporting materials.
Yes,
Liberty is there.
deeply obliged, Your Lordship.
Number 52.
52.
As per my instruction, my lord, that's section 32, my lord, limitation of the food safety and standard act.
But Mr. Gogoi,
Lordship,
there appears to be an infirmity
Lordship.
in the notice itself.
Understand.
Ekon noy, health and
7 days, 14 days, my lord.
no, that is not another.
No.
A downward food and food safety. I think this is a big book. What is the section?
32.
Improvement.
32. 32.
Yes, Mr. Bhuya,
My
what is a serious infirmity? You don't know.
Not skip my
32D, my lord.
No,
1D. 14 days, we will let you.
that is also not. 32. No, we have not go through. See the notice, impugn notice. Page 37.
My lord.
In the first case, right?
Lordship.
That is of the case of Mr. Robin Fukan. Page 37.
My lord.
See the letterhead. Office of the Designated Officer Food Safety.
My lord.
Now see the signature appearing, seal and signature. Food Safety Officer. Now come to page section 32. If the designated officer has reasonable ground for believing, okay.
My lord.
Now come to 36. The Commissioner of Food Safety shall, by order, appoint the designated officer who shall not be below the rank of a subdivisional officer, to be in charge of food safety administration in such area as may be specified by regulation. Then, subsection 2, there shall be a designated officer for each district. Okay.
Well,
now come to 37. Food Safety Officer. The Commissioner of Food Safety shall by notification appoint such persons as it seems fit, having qualification prescribed by so-and-so as food safety officers. Right. Now, section 32 empowers only a designated officer.
Well,
now, item number 55. Now, take the item number 55. For a moment, take the item number 55. Come to page 37 of that.
Singhal.
37. Subdivisional Officer Sador, Gulaghat, IS. Page item 55. Item 55. So there are two authorities. One is food safety officer and one is designated officer. Now, section 32 says it is only the designated officer who can issue an improvement notice. Now, take your instruction. Otherwise, this is not sustainable. At least in case of Robin Fukan. I don't know the next one.
Next for the same one.
Same. That may not be. Yes, you have the authority, but this notice is without jurisdiction.
They can initiate de novo by the appropriate authority.
That is what you will get the breathing space.
Then I will have a written instruction.
You get a written instruction.
Whether the food safety officer
is a designated officer. Because I have seen there is no provision to delegate the power of designated officer to a food safety officer. And so far, item 55 is concerned, but their designated officer has acted.
Yeah,
At least by
it will
page
have to be
37.
appointed, man.
That
It will have
will
to
not-
be appointed.
Uh,
Designated officer will have to be appointed.
Appointed by the commissioner.
Man.
Shreya
So
Singhal
food
is a
safety officer cannot issue a improvement notice also. Section 32 itself is clear.
my lord.
In fact, my lord, this particular, my lord, WPC, my lord, 791. 2024.
Their designated officer is there.
No, but because of why I'm saying is if in Golaghat, he is the designated officer. In that case, my lord, it's apparent, my lord.
Apparent.
Yes.
Still, I am asking for your instruction
Lots of lot. I will have it.
because we are acting at the motion stage itself. But that will not preclude you
Yes, for taking further course of action as per the law.
as per the law. So take your instructions so that we can dispose of all these petitions. At least item number
52 and
53.
First thing is.
We'll deal with the 55 in a different manner.
Lots.
Till then, some protections if my lord.
Day after tomorrow.
Yes. Again, I have it.
Oh, my.
Day after tomorrow only. If the foundation is removed,
Well,
the superstructure will fall.
well,
Third, Mr. A.R. Bhuyan, why you have taken the burden to this court? We are given the burden to this court.
sorry, my lord, and my lordship has gone more than us, my lord.
A.R. Bhuyan, learned counsel for the petitioner, and Mr. B. Gogoi, learned standing counsel, Health and Family Welfare Department for the state respondents. Mr. Bhuyan has learned counsel for the petitioner has submitted that the food safety officer does not have the authority and jurisdiction to issue an improvement notice under section 32 of the Food Safety and Standards Act, 2006. And it is only the designated officer who can issue the an improvement notice under section 32. So Mr. Gogoi, and standing counsel, Health and Family Welfare Officer, has got time to obtain instruction as regards as to whether authority and jurisdiction to issue an improvement notice under section 32 of the Food Safety and Standards Act 2006 can be delegated. Sorry, delegated to an food safety officer appointed under section 37 of the Act.
And one more query, my lord, lordship may kindly, my lord, ask the authorities to clarify as to under what provision of law this particular notices have been issued. If it is not under 32, in that case, my lord, it will be different tomorrow.
No, it is improvement is there. You take the instruction.
Oh, yes, page 37.
Because 32 speaks about only designated officer,
My lord,
nobody else.
no, regarding these notices, impugn notices.
And this is improvement, is it not?
Improvement notice.
Hmm?
Then I will have the instruction, my lord.
It is in the heading, my lord, it is an improvement notice.
Where is that? 37? This is.
Yes, improvement, my second para. Henceforth, my lord, that para.
Improvement measures.
Lots.
Otherwise, department will also suffer.
Yes, my lord.
Similar order in 54, 55. As so as sought for by the learned counsel for the parties, leaves the case of Wednesday. All on Wednesday, but so far as
55
and 54 is concerned, these instructions. We'll examine 55 Wednesday.
Obliged.
Item 53.
May I please, your lordship? Lordship, in this case, my lord, I am praying for some accommodation, my lord, because learned advocate general will lead us, my lord, in this case. We have some personal difficulty because one special DV matter is going on, my lord. So I am praying for day after tomorrow, my lord. I already informed the other side.
Okay, Mr. R.P. Kasuri, Learned Senior Counsel, Mr. M.E. Mondal, Learned Counsel for the petitioners is present. Mr. S. Dr. Learned Standing Counsel. Punjab and Rural Development Department has submitted that a sought for listing of the case on Wednesday in order to complete his instructions.
If possible, tomorrow, my lord.
Prayer tomorrow, the
Yeah.
prayer. In view of the prayer, submit, come and list the case accordingly on Wednesday.
Well, high level as well.
Number 56.
There were previous round of litigation before this honorable court. But your lordship will kindly see.
Some demolition had already
Yes.
taken place.
But when we filed a writ petition before this court, but demolition has taken place. So we thought that demolition has taken place, we should be given liberty to withdraw it and challenge the report. Only difficulty as on today is what we are facing, my lord, will kindly see. The demolition part, well, at page 79 kindly be looked up.
Page
This one, Hasan?
79.
Which
Which is your building?
Alert. This building start. Photo does it alert?
Left side.
Yes. My building starts from the ED, kindly see. From this where after footpath there is a staircase. Lordship got it? Staircase. From here to the last part. This staircase has been demolished. This staircase has been demolished. Now, photo dila. Now the position, kindly see the next page. Demolition has taken place. Is the part. Lordship has seen that which they have demolished. The at page 70, 81. 79.
Is there a byline?
Which, my lord?
Page 81.
Yes.
Is there a byline by the side, other side?
Side, my lord, there is a byline, but I cannot enter into it. My entrance into this particular shop or my diagnostic center is from here. So now there is the problem is that, very well, they wanted that they want to develop the drainage is the biggest problem. So I appreciate, my lord, drain is a problem. So we'll cooperate. The only problem is now I cannot enter. How I have to jump from here to there. So only some.
Who is the authority? Who did it?
Who authority? No.
Which authority did it?
Authority Deputy Commissioner.
Deputy Commissioner?
Yes.
Yes, madam.
What we can do a temporary measurement, we'll cooperate with them ultimately. Well, I think your lordship will be difficult to enter into the area. Whether which area has been encroached, which has not been encroached. Only I told my learned friend, only to the extent the ingress egress, some cooperation if they do it, we'll go with the with them, with the authority. Because otherwise, what has happened now, the underground, my lord, there is some car parking. Now there is some electronic machine. Suppose there is some rain, heavy rain, then it will be problematic, will be there. If they can take instruction, if this part, see, my lord, your lordship cannot.
Some way temporary.
Some temporary measurement and in the
Take the
meantime.
instruction. In the meantime, whatever you do, but so far as entry into this portion.
I have to take instruction.
You can take instruction, my lord.
You take instruction.
Yes.
By Friday. Because
temporary measure if
everybody may not be able to jump.
Now patients are there. What I have been told, diagnostic center is there.
Whether a temporary wooden structure.
Yes, some are. That's why same I told my lord. Whether wooden structure can be put with them.
Installed.
Temporary.
It will be hardly about 5 feet. 5 feet?
Yes, 5 feet, no? 5 feet.
Maybe 5 feet.
Yes.
5 feet, 6 feet. Yes.
And if you lodge it kindly. See,
Take instruction. But that is your interim prayer.
yes, that is my interior, my lord. And at least ingress and egress, people doesn't get suffered. And some temporary.
Hmm. Yes, madam, can you take instruction?
Yes. Yes, Lord.
Heard Mr. Didas, Learned Senior Counsel, assisted by Mr. M.H. Law School, Learned Counsel for the petitioner. And MS and Bordelais. Standing Counsel Revenue and Disaster Management Department for the respondent number 1 and MSS Borua. Junior Government Advocate Assam for the respondent number 2, 3, and 4. The petition, it is a case of a petitioner that by undertaking a demolition exercise on
Demolition. 29th of January.
29/1/2024. The respondent authorities had demolished the front part of the petitioner's building consisted of stairs.
Yes.
On the ground of alleged encroachment of government land. As a result, the as a result of such demolition, the entry and exit to the petitioner's building has become impossible. Because of the petitioner who runs a diagnostic center
Yes.
in the said building.
And other shop is also there. Connected shops are also there.
Treating patients and as well as business of other commercial establishments of the said building has been seriously affected. Apart from other contentions, the petition has sought an interim relief in the form of a temporary arrangement within bracket wooden stroke steel structure, in the front side of the building for entry and exit. MS Borua shall obtain instruction as regards the interim relief sought for, as indicated above.
A copy of order, kindly furnish the copy.
Okay. Mr. Loskor, learned counsel for the petitioner, shall furnish a copy of the petition along with annexer to Ms. Burua during the course of the day. As requested by Ms. Burua, a copy of this order be also furnished to her for taking necessary steps from her end. Right? Is the case on Friday?
Friday will be better because let her take some time.
Fine.
So that he gets the
You take the instruction wooden structure,
only wooden structure.
wooden stairs,
Wooden set
Right?
temporarily.
temporary,
And-
temporary wooden.
Wooden and they will remain also while constructing also. Thank you.
Item number 4.
Yes,
Lordship, we have filed affidavit today, Your Lordship. We are disputing the facts submitted by the petitioner in the writ petition, Your Lordship. The affidavit may not be in the record, Your Lordship. May I place? May I read, Your Lordship? In paragraph 9, we have stated that the deponent begs to state that there is no scheme as mentioned by the petitioner in the writ petition, that is beautician and development of ecotourism of river Moravarali from Porua Sariali to Kolaguru Vishnupakad Rabha Samidhi. The correct name of the scheme is Bank Protection of River Moravarali from Porua Sariali to Kolaguru Vishnu Rabha Samidhi Phase 1. The decision of the project was taken in the cabinet meeting. Government of Assam held a test tour on 11/6/2022. The state project will not require any land of the petitioner or land acquisition is not required for the state project, Your Lordship. The deponent denies the statement of the petitioner that some person official of the Water Resource Department Sonitpur made some preparation to evict the petitioner from his land. That is the main contention of the, and we have stated that all facts.
so
are
there is
disputed
no requirement of
land.
petitioner's land.
That
First
is
part.
our objection, yeah.
Second, whether there is any art cutting.
No, Your Lordship, as per our instruction.
Okay,
there is
Mr.
no
Mohanto,
land.
let the affidavit be on record.
My lord, kindly have a look at page, my lord, 20. My lord, yes, 30, my lord, annexer 4 of my petition, my lord. This is the, my lord, the name of the project which I acquired from their office. The name kindly say, my lord, this is, they now saying that this is not the project. I don't know, my lord, on which project they are speaking, but project is this, my lord.
Which one?
My lord, the top, in the bottom of the, my lord, this annexer 4 at page 30, my lord. The name of the project in the box, my lord, this is.
Box.
Yes, my lord. The small letter, my lord. Difficult to read, my lord.
Beautification and development.
Yes, my lord.
So out of that, this road
I don't know.
come embankment with paver blocks.
I don't know, my lord.
Okay, since they are appearing and filing affidavit, let us issue the notice first.
Yes.
In the meantime,
Moreover, my lord, one thing, my lord, they have.
any other private respondents? No.
No, my lord, no. No, my lord, no,
Then
moreover.
we can issue short notice, right?
And they
You
are.
have received the affidavit.
Yes, I have received, my lord.
Okay.
And the para 7, they kept open one para in respect of the 0.4, my lord. I don't know, my lord, on which aspect they are speaking. This 0.4 deponent begs to state that it is not under the purview of the Water Resource Department. I don't know.
Let it come on record, then we'll ask MS Deka.
Yes, ma'am.
Heard Mr. P. Mohanto, learned counsel for the petitioner. MS R. Deka, learned counsel representing Mr. R. M. Das, learned standing counsel, Water Resource Department. Order respondent number 1, 3, and 4. And Mr. N. Goswami, learned junior government advocate Assam, for the respondent number
2 and 5.
2 and 5. To stop. MS Das, MS Deka has submitted a counter affidavit on behalf of the respondent number
2, Your Lord. No,
Two.
no, Your Lord, 3.
3 has been is being filed today. To stop. Issue notice returnable on 6/2023. As the learned, as all the respondents are being represented by the respective council, no formal notice to the respondents is necessary. Need any extra copy?
No,
Okay, okay. Please the case. 6.
Must be.
With the affidavit stated to have been, with the affidavit of the respondent number 3 on it.
Item 10.
Must be.
Obliged.
May it please, your lordship. My lord, my case comes under this Assam Employees Pronam Act.
Assam?
The Assam Employees Pronam Act, two thousand
Assam
seventeen.
Employees Pronam Act.
Pronam
This
Act.
I have heard. Huh?
2017.
I have heard for the first time.
My lord,
Assam employees.
My lord,
Is it enclosed here? Yes.
Chief Minister of Assam times and again
Which
in
one,
the
which one?
TV televised this.
Page.
My lord, so my lord, what have-
Page.
no, my
What
lord,
is the scheme?
my lord, scheme I have not, I have the act, my lord.
Ah, what is
Yes.
that act?
Yes.
Let us have a look.
My lord,
I don't know.
I've tagged it, man. Yes.
How is it different? You know?
My lord, provision of the act is this, my lord, the government employee or employees of an organization notified by the government. The employee do not look after the parents, my lord. Then 10% of their salary may given to them for their subsistence.
If that is your case, then this is a service matter.
My lord,
Is it a service? Because it is your, that you are asking for what?
my lord,
Your parent,
yes, mother, my lord.
mother,
Widowed mother.
and thing is to be deducted from whom?
From the
Your son,
implied son, my lord.
from his salary,
Yes, man.
under the provisions of this act.
Yes, man.
Then whether, I think it is his service,
Yes,
or
service.
bench 4 or bench 5 or bench 3. I think it is related to his service.
Yes, my lord, service.
His employer will come into
Yes,
picture.
maintenance,
I think
maintenance.
employer will deduct.
Employer will deduct, authority is there, designated authority.
Yes. State Council, is it a bench 5 matter? Because mother is asking a part of the son's salary.
Hmm.
And under the statutory provisions of Assam Employees Pronam Act, I think it is related to his service.
Definitely, related to service.
Bench 3. Heard Mr. M. A. Sheikh, learned counsel for the petitioner, and Mr. N. Goswami, learned junior government advocate Assam, appearing for the state respondent, have submitted that the subject matter of the writ petition pertains to bench 3, post of the registry to ascertain, and thereafter list the writ petition before the appropriate bench. I think it is.
My lord, may I pray that in the next week, madam, because there is hardship on the part of the mother.
Oh, you mainly in the motion column.
My lord,
Before the appropriate in the motion column. That will expedite.
my lord, oblige me.
Item number 11.
May please, the matter pertaining to the Provident Fund account of the petitioner, my lord. The petitioner entered into service in 1998 as money in the establishment of district judge Kamrup, my lord. And he was attached with the district judge. And on transfer of the district judge to defense station, he was also transferred as casual worker. He entered into service in 1998 as casual worker in the establishment of district judge Kamrup, my lord. And he was attached to Grand District Judge. He was attached to the district judge, and thereafter on transfer the district judge to different district, he was also transferred.
What has happened here?
My lord,
What has happened?
brother, he has entered into Provident Fund account in 2007, my lord. Annexure 6, my lord, page 46.
Page 40?
And page
Six.
38, page 38, my lord.
I am to invite a
This is the application.
above and stated as per defined benefit of pension.
Here's
So earlier it was GPF,
Yes, it is, my lord.
GPF.
GPF.
Then
He has applied for GPF in 2007. It was open. His GPF number, my lord, the ORS 7709. Next page 39, my lord. And
page
39.
39.
And the statement issued by the GP, we are enclosing the latest statement because earlier it was missing. Latest, my lord, up to up to, my lord, 2023, my lord. 2023, he has deposited there and Provident Fund account, my lord, amount added at rupees 2,000 per month. And
So it was GPF.
GPF, my lord.
Yes.
Yeah, he has the accountant general has accepted his deposit and the interest rate accrued in that way 2007 to 2023. You are deposited, but suddenly, my lord, accountant general, my lord, has issued a notice of post page 36 annex 8, my lord, of 46, page 46, my lord. This is the notification issued by the accountant general, my lord. The to the district judge, I am to invite the reference to the subject cited above and to state that as per para 4 of the existing provisions under the defined benefit of the pension GPF would not be applicable to Assam servant joining.
Okay, now what is this division bench order?
My lord,
What is this division bench order?
a division man saw earlier, 2006, when he was regularly appointed as peon, he was not paid salary on the ground that the financial sanction is not granted by the
Now,
finance.
when your service was regularized,
My lord,
when your service was regularized,
regularized in 2005, my lord.
on what date?
15th one.
On December 20, 2005.
2005. Then we'll examine this matter.
2005, my lord.
Annexer,
That is
page 33. Document C.
Page 36, yes. Page 35, my lord. The annexure T, on recommendations of the selection board under the establishment dated 27/6/2006, Bipul Kumar office peon of the Municipal Bajari Patsala is promoted to the post of Jarikar. 2016, he was promoted to the post of
No,
Jarikar.
no, when your service was regularized.
Page 33. Page 33.
33, my lord, this is the
1st of
appointment
December
letter.
2005.
And that is reflected in the consent
That
order,
is-
so my lord will find it page 51.
People.
Prior to that, he was not regularized.
My lord. 2005, he was regularized, my lord. And my lord, the India letter, this is not the question of regulation. They have written in Annexure 8, my lord, the Assam Financial Department, letter number so and so.
These are policy decision, Mr. Sharma.
Division bench has already recognized.
Division
that.
bench has directed regularization.
No, I have not.
Let us see the,
No, the petition was.
let us see the division bench judgment. What is the purpose? You can petition.
I'm allowed to read out the division bench judgment, my lord.
There has been appointee.
Page 52.
Para 2 of the page 50, para 2 of the.
Non-payment of salary.
Exactly, madam. No. It is financial, later it was discussed. We have filed a case for financial, for paying the salary without the financial required sanction, my lord. So on that point,
So since when you are getting skill?
My lord?
Since when you have been regularized?
I have been regularized in 2005, my lord.
December 2005.
2005, December.
And this GPF withdrawal, that decision was taken with effect from 1/2/2005.
That is
We'll examine this issue.
No, who has joined the service in the 2005 as per circular, my lord. Joined, not this question of regulation, my lord. You will also kindly see the page 46. it is very clear, my lord. Who has finance budget department letter number so and so of the GPI account allocated to the applicable to Assam government servant joining government service on or after 1-2. It is joining, not regulation. I have joined in 1998, my lord.
We'll examine, Mr. Sharma.
My lord,
We'll examine the case.
no, we have and that I have I have entered into service in 98, and that has been recognized by the division bench also, and that thing has been discussed. And so he has also discussed the condition of service, regulation of service by the High Court in case of employee, my lord. In case of judicial employee, my lord. You will also kindly see the page 50, paragraph 2 of the division bench judgment. The read petitioner on the basis of the appointment order dated 2198 issued by the district and sessions of so-and-so Guwahati was appointed as money and fixed salary of rupees 900 per month. It is evident the appointment has been made.
Fixed salary. Fixed salary 1998.
Fixed salary, yeah, fixed salary, not irregular. But he entered into service, my lord. Yeah, in the as per circular.
Examine whether your
the circular
case should be considered from 1998.
as per this circular.
See on the basis of law, established law.
No, it was, my lord, I have joined the service in 98, my lord, and opened the Provident Fund account in 2007. But since 2007, they have been taking deposit of my Provident Fund, my lord, up to 2023. And we have taken loan of the rupees 70,000 from the Provident Fund, and that was granted and repaid. And my date of birth was also wrong, that was also corrected. For so long 2007 to 2023, I was allowed to deposit the amount.
Is it,
And that circular,
are you the isolated one?
no, that circular. Which
You
has
are the
been-
only chosen one.
My lord?
Out of thousands of employees, are you the only one?
No, there are so many things. I have not brought it today. There are so many.
Well, you should notice at this stage, mister.
By RTI, I have found so many, but those have been found after filing of this case, my lord. So I could not accept it. If your lordship want, I can file it in next week even after joining of the 2007, the Provident Fund has been regularized, my lord.
If you are illegally treated, your situation will be restored.
My lord?
If you have been illegally and discriminatorily treated, your position will be restored.
My lord, High Court has recognized that I have been joining the service in 98. Your lordship kindly see the under.
Joining the service on fixed salary and regularization in the year 2005 is completely different matter.
As per circular, who joined the service after 2005, joined, not as regular. As per this circular.
Authorities are galore, Mr. Sharma.
Your lordship kindly see the page 56 of the division bench judgment.
You want the case to be decided in the motion stage.
Yes. No, here, my lord, page 56, your lordship kindly see. High Court has said it would be the High Court alone and not the government of Assam or the Department of Finance who should exercise control on the mood and manner of appointment.
How much time will take for arguing?
My lord?
How much time you will take for making submissions?
No, my submission, my lord, notification and the annexure may be state, my lord. If the annexure may be state, otherwise, I moreover.
Persuaded at this point of time.
Moreover, in the circular, I have been deposited the amount up to
You want to-
2023.
We can issue notice on the interim prayer, but if you want to say that your interim relief should be considered, we'll consider now.
Yes, interim relief, otherwise my case will be.
Okay, make submission on interim prayer.
Otherwise, my.
Okay, make submission on interim prayer.
No, my lord.
Make submission on interim prayer.
Interim prayer, my lord.
Otherwise, I am interested to issue notice on the interim prayer.
Interim prayer is not granted.
If you want the decision today, we'll decide.
No, my lord, if the interim prayer is
If
not.
you are
granted-
aggrieved, intra-court appeal is available.
No, interim prayer is not granted, then my case.
Just
will be
tell me,
success, my lord.
what do you want? What do you want?
All a notice may be issued.
Heard Mr. K. Sharma. Learned Counsel for the petition. Mr. S. Borua.
Yes.
Lord Junior Government Advocate Assam for the respondent number one. Mr. Z. Boshwal, Lord Standing Counsel. ZHC for the respondent number 2 and 3. Mr. R. Borbuzari, Lord Standing Counsel, Finance Department for the respondent number 4. And Mr. R. K. Talukdar, Lord Standing Counsel, Accountant, R. Talukdar, R. K. Talukdar. Lord Standing Counsel, Accountant General, A and E, Assam for the respondent number 5. The case of the petitioner, comma in brief, is that he was initially appointed as Mali on 20/01/1998 in the establishment of the respondent number. In the establishment of a district and session judge, comma Kamrup, at a fixed monthly wage of rupees 9,000. The petitioner came to be posted as a regular peon. As a peon with regular scale of pay. WEF 1/12/2005. And since then, and the petitioner was thereafter promoted to the post of Jari Karak on 28/2/2016. And the petitioner is serving as Jari Karak. No. The petitioner was thereafter promoted to the post of lower division by an order dated 15/12/2020. The grievance of the petitioner, the petitioner was brought under the purview of the GPF scheme since the year 2007. 2007?
Yeah, 2007 years after.
And contributions were regularly deposited in the GPF account of the petitioner till
2023.
2000, which month?
Next.
December 2023. The petitioner is aggrieved by the impugned decision conveyed by the impugned letter dated 16/11/2023 within bracket annexer 8, whereby it has been informed that the GPF scheme is not applicable to the Assam government employees who had joined service on or after 1/2/2005. Post op. As per a circular stroke notification of the finance within bracket budget department dated 27/9/2011, comma, GPF accounts allotted to government employees by the Accountant General Assam and contributions made thereof would be refunded with interest up to the month of December 2011. And there would be no claim of interest on GPF accumulated amounts beyond 31/12/2011 post by the impugned letter dated 16/11/2023, comma, the district and session judge, comma, Bozali, has been requested to direct the petitioner, comma, a subscriber of GPF account number ORS/7709 to submit his final withdrawal application. Full stop. Aggrieved thereby, the petitioner has preferred the instant petition. Full stop. The petition has sought also an interim relief in the form of stay, suspension of the impugned letter dated 16/11/2023, insofar as the petitioner, insofar as its operation in respect to the petition is concerned, issue notice returnable in 4 weeks. Notice be also issued on the interim period, as so and so appeared accepted. No formal notice, extra copies within 2 working days.
Providing personal security officer at his own expense. My lord, what happened? The petitioner is a social activist in Hoskwa Sapori village of Tezpur.
We can note,
He was
notice at this stage, mister.
and pendency shall not be a bar for consideration of his prayer, my lord.
Let them.
Because already there is an attack, my lord. I have annexed the photographs and medical documents. It was a serious attack, my lord. His body was sliced like anything.
Heard Mr. H.K. Das, the counsel for the petitioner. Mr. S. Borua, learned junior government book Assam for the respondent, all the respondents.
Okay, all the
Full stop. The petitioner has preferred the instant petition. Seeking a direction to the respondent authorities to provide personal security officer, PSO, the petitioner, forthwith and acts at the expense of the petitioner. Post of issue notice, returnable on so and so. As Mr. Borua, learned junior government advocate, has appeared and accepted notice on behalf of all the respondents. No formal notice to the respondents is necessary. The learned counsel for the petitioners shall have furnish requisite number of extra copies of the petition along with annexure to Mr. Borua within 2 working days. Post of the petitioner has submitted that petitioner has already prepared a representative application seeking for personal security officer, PSO. Also, it is observed that pendency of the petitions shall not be barred for the respondent authorities to consider the said application.
deeply.
For admission account number 22 to 24.
Please, Your Lordship, the previous counsel on record, my lord, had to withdraw because of a medical emergency, my lord. Because in this case, what has happened is that the property of the petitioner in 22 and as well as 23 and 24, my lords, on these three.
22.
Yes,
22
my
is
lords.
49421.
Lordship, 4921, my lords.
Okay.
And my lord, also in 23 and
Okay, we'll
24.
see one by one. Let us see the first case first.
First case. But in this case, my lord, there is an order of taking coercive action. If your lordship will kindly have the order dated 28/7, my lord, 2023.
28/7.
2023, my lord, Justice Barwa's.
28/7. Here the first order is on 1/8/2000.
Yes, 1/8/22. That was your lordship's order. Following, my lord, similar orders in other two cases, my lord, which are in fact 23 and 24. My lord. Lordships had followed the earlier orders and passed the
Let us
orders.
see one of the order earlier.
That order would be, my lord, 1/8/22, my lord, lordship's order.
12/7.
Yes, 12/7 is Justice Medhi's order, my lord.
Okay.
And
that's
lordship's
it.
order is there, my lord, in
Okay,
4921.
we'll see first 12/7. On the basis of that, the other order was passed.
Yes.
Hmm. Notice. Annexer 5. Annexer 5.
Initially, my lord, there was this notice.
Annexer 5. Okay.
Yes, there was this notice, my lord, which was challenged.
Overlook account. This is general notice.
Yes, that was because of the vagueness of this notice, my lord. Lordships had interfered, my lord, at that stage and protected the petitioner from the.
Drawing attention to the
At that
so submitted is general one referring and proceed to packet. And this petitioner has periodic patalan.
Yes, periodic but those
Okay.
documents are on record, my lord. They are not, my lord.
Let us see the
Dispute.
documents.
Yes, lordship will have the amended petition in 4921, my lord. Because the petition was amended.
No, 494596. Let us see.
4596, my lord, I must say that there is no affidavit in opposition.
No affidavit, mister.
No affidavit. 23, 23, no affidavit.
We have filed an affidavit in item number 22.
That was the case of this petitioner.
No, my lord, what I am submitting is that, my lord, there are three petitions. Subject matter is analogous and, my lord, same. My lord, we have.
Same, but I want to know that so for 4921.
4921.
As well as I have just seen 4921.
Yes, my lord.
And 4596.
Yes.
Let us see the third one also.
Yes.
Third one is, my lord, 4597.
One. Every petitioner has claimed that he has periodic pattalans.
Periodic patalan.
Right. It
Yes.
is not that they do not have any land holdings.
Yes, yes.
Or that
Yes.
or they are occupying government land or something like that.
They say, my lord, that they are not occupying government land. They are having periodic patta and they are in occupation of their periodic patta land. Now, by dint of this notice, my lord, they are sought to be disturbed. This is their precise case. Now, we have filed an affidavit, my lord, in 4921, the first item. And the amended writ petition is with regard to, my lord, 4921.
492.
492. So that is a comprehensive writ petition. We have filed a detailed affidavit, my lord. And that affidavit, my lord, in my respectful submission will, my lord, cleanse the entire issue.
But
No,
there is
what is
one
the amended writ petition.
Yes, no, there is one crucial difference.
Let me understand.
Lordship.
I cannot go in piecemeal basis.
No, no.
What is this land acquisition case number 2 of 2022?
Yes, for that, my lordships may kindly have, my lord, page 40. of the amended writ petition, because the amendment was pursuant to, my lord, that is the difference between item 22 and 23-24, my lords. That aspect will be clear.
I'm looking at page, okay, you read from
Yes,
page
page
40, I am
40.
looking at page 42.
Lordship, in the land acquisition case number 2 of 2022 dated 9/9/2022 of the Deputy Commissioner of Sonitpur, under notification so and so, notice is hereby given to the landholders and other interested persons whose land has been acquired for construction of flyover bridge at Mission Chariali are asked to receive compensation by being present along with the below mentioned documents in the office of the Deputy Commissioner during office hours.
What is this notification 9/9/2022?
This notification, my lord,
Now that situation has changed now.
Situation has
They are asking
yeah,
to receive to compensation.
compensation, my lord, and
Let
as
us
per
see
the
that, where is that? Is it annexed somewhere?
Yes, that my lord will find at page 43.
40.
43. Because, my lord, this land acquisition case, my lord, for construction of flyover that has been drawn up in accordance with the provisions of the land, Assam Land Requisition Act, my lord.
What is the
Right.
purpose of this?
My lord, for construction of flyover over national highway. Now,
Is it a case of requisition?
No, it will be first requisition, then it will be acquired, my lord.
When knowing fully well, this is a permanent thing which is never going to be returned back.
Yes,
This land, see, requisition is, ownership is retained by the owner, possession is taken over,
absolutely.
right?
Yes,
In acquisition, both possession and ownership is taken over. Then knowing fully well it is a overbridge. Why you have resorted to this requisition process? Tell me the logic.
yes. Now here.
To understand the logic, please tell me.
Yes.
What is
Now,
the logic?
yes, logic is that, my lord, over the national highway, my lord, at Mission Chariali, Tezpur. Now.
Is it a national highway?
Yes, it is a national highway. Now, my lord,
What is the process of acquisition of national highway?
yes, now here.
Land in for national highway, what are the processes?
National highway, my lord, there are threefold, my lord. Yes,
me.
yes. First, we can, the authorities can resort to the National Highways Act 1956. There are provisions therein. Authorities may also resort to, my lord, the 2013 Act, and authorities may also resort to the State Acquisition Act. Now,
What is the law? Which law permits you?
my lord, Bangalore Development Authority. And right now, I don't have the decision, my lord. I may have it.
the State Act is of 1964. Assam
State Act.
No. First, let me understand. When it is a national highway, it is national highway.
National highway.
It is to be declared under the national highway,
National highway.
under no other act,
No other.
right?
Yes.
So national highway means it is to be acquired by the central government.
National highway to be acquired, but
There is no dispute to the same proposition.
yes,
Now,
yes,
to acquire that land for the central government, one is National Highway Act 1956. What are the other mode of acquisition?
other mode of acquisition, my lord, 1964 Act may be resorted to, whereby, my lord, the beneficiary, my lord, the requiring department, we have spelled it out in our affidavit. The requiring department is the PWD. It is the PWD, my lord, who will be, my lord, taking up that land. And they will construct, my lord, along with National Highway authorities. This provision has been, my lord, resorted to ease out the process and to, my lord, speed up the process, because these are national infrastructure projects.
National infrastructure project right now,
Absolutely.
yes.
Yes,
What sanction you have obtained for national, if it is national highway,
yes.
right?
Yes.
How can you resort to this requisition process?
Now, my lord, that is
Just to
not,
understand.
yes. Now-
Because this is, I am
yes.
seeing this kind of thing,
Yes,
because with my limited knowledge, I understand that
No,
national highway is under section 150, section 2, National Highway. And it is a prerogative of the central government only
yes,
to declare a national highway.
yes.
And the land after acquisition vests with the central government,
Central government,
right?
yes.
There is
Now, if
no
I-
dispute to the state proposition.
Yes, now, lordship may.
Now, why this requisition process, I have not understood. So please.
Yeah.
Uh,
Your Lordship, may for-
National Highways Act.
Yes.
National Highways Act.
at the first
There is section 2,
section 2.
declaration of certain highways to be national highway. And that has been explained in number of decisions that it is the only central government.
Only section.
They can say any land as national highway.
Yes. And my lord, 3A provides, my lord, the power to acquire land. 3A. Where the central government is satisfied that for a public purpose, any land is required for the building, maintenance, management, or operation of a national highway or part thereof, it may by notification in the official gazette declare its intention to acquire such land. So therefore, meaning thereby, my lord, that the central government has the pure prerogative, my lord, under the provisions of this act, to go for acquisition. Other provisions are, my lord, hearing of objection, those lordship is well
Where
aware.
is the central government notification?
Yes, now lordship, this is one aspect of the matter. Now lordship may kindly take up, because here the affidavit is important. Lordship may kindly take up the affidavit.
I'm into the power.
No, power, my lord, I'm explaining because the facts, my lord. if lordship
Facts
permit-
later.
Yes.
Facts comes later.
Yes.
Let us see. Okay.
Yes.
Let us go to the
Yes,
affidavit.
the affidavit, my lord, it has been filed by, my lord, the additional district commissioner. It starts from the running page 52, my lord. Dear my lord, may kindly come to paragraph 5. My lord, I am reading it, my lord. With regard to so and so, the deponent respectfully states that it is a fact that a flyover is under construction at Mission Sariali, Tezpur, which will cover an area from so and so to so and so over the National Highway 15 in public interest. For construction of the said flyover, apart from utilizing the existing highway and road reserve lands on both sides of National Highway 15, some private lands are also being acquired. The land acquisition process for the same is under process. However, during field survey, it was found that some illegal encroachment on the road reserve of National Highway 15, which are government lands. Some encroachment are illegal and are liable to be ejected from the government land under provisions of Rule 18 so and so. The public notice dated 1/7/2022 was served upon exclusively on such enclosures on reserve land. Then paragraph 6, my lord, perhaps will, my lord, answer my lord's query. Paragraph 6, the next paragraph. With regard to the statement so and so, deponent respectfully state that acquisition of private land for the purpose of construction of flyover at Mission Sariali, Tezpur has already commenced under the provisions of Assam Land Acquisition 1964. The requiring department in this case is Public Works Department, Building and NH Division, Government of Assam. So they are, my lord, resorting to construction. The chief engineer so and so, by his letter dated 21, communicated for acquisition of land as per provisions of Assam Land Acquisition and Acquisition Act 1964.
Is there any already decision?
My lord,
Is there already a decision? This kind of acquisition is colorable exercise of power?
my lord,
Tell me. As an officer of the court,
yes. Now, if we go to, yes,
as an officer of the court, tell me, is this kind of requisition process,
my lord.
has it been declared by this court? As an allowable exercise of power or not?
My lord,
Tell me, as an
yes,
officer of
yes,
the
yes,
court,
my lord.
then,
My lord, faithfully submitting, my lord, I am not ever till now, my lord.
no, is it so or not? I am asking, I have also
Yes, yes.
some doubt.
No, no, absolutely, lordship is correct.
Is there a decision already?
My lord, I will have to check it out. I will have to check it out.
See, by the nature of the acquisition,
Yes, my lord.
national highway, it is a permanent thing. Ownership as well as possession, both are to be taken over. It is not the case of possession that after the flyover, after 5 years, it will be dismantled and land will be reverted back to the pattadas. It is not the case,
Absolutely.
right? So, just for the sake of expediting the process, does it not appear to be a colorable exercise of power?
Yes, my lord. To that extent, my lord, I will respectfully submit, my lord, I may draw my lord's attention to the provisions of 1964 Act.
Tell me whether there is already a decision.
My lord, one decision was there, my lord, where my lord, conflict of my lord, Central Act, Land Acquisition Act, my lord, in Bangalore Development Authority case, my lord.
What is that?
What has happened there, my lord? In Bangalore, my lord, the authorities resorted to, my lord, acquisition of land under a local act, Bangalore Development Authority Acquisition Act. Challenge was made, my lord, before the High Court, Karnataka High Court, that, my lord, that authorities could not have resorted to, because at that point of time, 1894 Act was there, and in the meantime, 2013 Act has come. Supreme Court has struck a balance. Matter finally went to Apex Court. Apex Court, my lord, struck a balance, my lord, and said, my lord, because, my lord, under the Constitution in list 2 and list 1, my lord, concurrent list and, my lord, that state list also, power to acquire land is given.
Both given.
Both to the state government as well as.
But for National Highway,
Yes,
it is NT 23 list 1.
NT 23 list 1. It's,
Now, tell me that.
now, my lord, in one case, recent case, my lord, of course, my lord, that matter pertains to, my lord, setting up of a petroleum storage terminal, my lord, by the Numoligo Refinery Limited in Hingimari, my lord, Kamrup Rural District. And the acquisition process was started under the provisions of, my lord, 1964 Act. Now, that acquisition process as a whole was challenged before this honorable court. Our coordinate bench of this honorable court negated it, my lord, taking a cue, my lord, from, my lord, that dictum in Bangalore Development Authority.
What the Bangalore Development Authority has,
Yes, my lord.
how the balance has been struck?
Yes, my lord.
Can you give the citation?
Yes, yes, my lord.
Because see, these are periodic patterns.
Yes.
Firstly, maybe there could be a encroachment,
Yes,
but at the same time, they are a holder of periodic patterns.
my lord.
It is not the case of these petitioners that they are, or not the case of the respondents also, that they are encroachers of government land. They could be in the process of holding this periodic pattern lands. They could have gone beyond their land holdings and in the process encroach a part of the pattern land.
That is what, my lord, we have specifically pleaded in the affidavit. Now, here it is not the least even, my lord, projected by the petitioner that they are challenging the acquisition process.
Yes, these petitioners are agreeable for compensation amount or what?
Yes.
Or you are challenging something?
No,
My lord, the
kindly see.
fact remains,
One minute.
the fact remains that, my lord, in 22 only, my lord, the first notice was 17/2022, which was the general notice. That was regarding
What have
encroachment.
you, in the amended
Lordship.
petition, what have you challenged? Let us
For a moment, my lord, yes,
Remember the amended-
to act illegally
yes.
on the strength of so and so from
Page 21, my lord, is the prayer person. Restrained to act illegally on the strength of public notice that.
amended, okay.
Yes, amended.
Yes, amended.
Amended writ petition, my lord, page 21. Page 21 is the prayer person, my lord. Restraining the respondent authorities on the strength of public notice from removing any alleged encroachment from the government reserved roadside land and to disturb the possession of this petitioner on her land so-and-so situated so-and-so and removing or dismantling so-and-so and property including the building belonging to the petitioner without giving sufficient time to raise her grievance and giving her proper hearing.
Yes, both because otherwise National Highway Act provides for various stages, right from 3A, 3B, 3C, 3D, 3E, 3F, 3G.
Yes, up to. Objections, my lord, yes, it is there.
2013 Act also provides.
2013 Act, but it is not so, my lord, in the
Not
case of
so.
in case of 1964 Act.
That
Yes.
raises a doubt.
Yes, but it is the admitted stand of the petitioner. If my lord may be pleased to come to page 10 of the writ petition for a moment, my lord. Page 10, paragraph 10.
Because state has to be fair, right?
Absolutely, yes.
At all the stages.
Yes, yes. Paragraph 10, that this petitioner is not averse to any developmental project. If the proposed construction is going to ease the traffic, she will gladly allow any sort of acquisition.
But that says all acquisition cannot be divorce the law of the land.
But yes, that is true.
Now, what is your notice?
The notice is only with regard to removal of encroachment.
Let us see rule F4 and section 3(1).
Yes, section 3.
Assam land acquisition and acquisition.
Yes, my lord. Lordship may kindly peruse section 3. Power to requisition. May I read it, my lord? If in the opinion of the state government or any person authorized in this behalf by the state government, it is necessary to do so for maintaining supplies and services essential to life of the community, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, and anti-erosion measures. The transport is, my lord, covered under section 3.
This is highway. This is highway.
No, this is highway.
Let us read.
Yes. Including embankment and drainage, or for providing land individually or in groups to landless, flood-affected person, displaced person, so and so, form for the benefit, including border roads and checkposts connected therewith along with Bangladesh border, the state government or the person so authorized as the case may be, may by order in writing requisition any land and may make such further order as appear to it to or to him to be necessary or expedient in connection with the requisitioning. Now, we have specifically stated in our affidavit that the quantum of compensation that will be determined, my lord, that will be paid as per the provisions of, my lord, in tandem with the provisions of, my lord, the 2013 Act as well as, my lord, the 1956 Act. That we have spelled out, my lord, at paragraph 6 of the affidavit in opposition.
See section 4.
Yes.
See section 4.
Power to take possession of requisition land where any land has been acquisition under section 3.
Requisition. 4. Section 4 of the 1964 Act.
Yes, my lord. 1964.
Is it? What is the heading?
Heading is, my lord, power to take possession of requisition land. Where any land has been requisitioned under section 3, the state government or the person authorized in this behalf by the state government may, by order in writing, direct the owner, the tenant, or any other person who may be in possession of the land, whether at the time of requisition or at the time thereafter, before the land is released from requisition or under section 8, to surrender or deliver possession thereof to the collector or any other person duly authorized by him in his behalf within such days of the service of the order as may be.
So it talks about possession only.
Possession. And thereafter, my lord.
Let us see the provisions.
And then, my lord, section 6.
5 also.
Yes.
Let us understand the object and purpose of this.
Yes. Repairs to building, section 5, where any land with building standing thereon is requisition under section 3, the state government or the person authorized in this behalf by the state government may order the owner to execute such repairs as may be necessary and are usually made by landlords of that locality as may be specified in the notice issued in this behalf within such reasonable time as may be mentioned herein. And if the owner fails to execute any repairs in pursuance of such order, the state government or the person authorized in this behalf by the state government may cause repair specified in the order to be executed at the expense of the owner and the cost thereof may.
So till the stage of section 5, it is owner, landlord. Let us read section 6.
Yes, section 6 is, my lord, the final culmination. It is acquisition. Where any land has been requisitioned under section 3, the state government may use or deal with it in such manner as it may appear to it to be expedient and may acquire such land by publishing in the official gazette a notice to the effect the state government has decided to acquire such land in pursuance of this section. Where a notice as aforesaid is published in the official gazette, the requisition land and premises shall, on and from the beginning of the day on which the notice is so published, rest absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end.
Subject to the provisions of this act on such vesting. The
My-
provisions of land acquisition.
Yes, subject to the provisions of this act on such vesting, 1894 with the rules framed thereunder.
Now let us come to the order. In exercise of power under so and so.
Order, my lord, at page, my lord, 43 of the writ petition. In exercise of the powers conferred on me under section 3(1) of the Assam Land and so, notification so and so, I do hereby requisition under section 3 of the Assam Land Requisition and Acquisition Act, the land described in the schedule below with effect from the date of this order for construction of 4-lane flyover at Mission Sariali under Dashpur Revenue Circle. So here, my lord, the construction will be done, my lord, by the PWD. And at page 44, Lordship will see, page 44, the next, very next page, my lord,
Now
down,
read rule 3.
my lord,
Rule 3
rule 3,
of that.
yes. Manner of submission and representation by interested person where land is necessary to be requisitioned for landless or displaced persons. Now, rule 3, my lord, in my respectful submission will not be attracted in the case, my lord, because it's the construction of, my lord, flyover. Where it is necessary to requisition any land for landless or displaced person, the person interested in the land shall be informed of the intention of requisitioning his land, and such person may make written representation, if any, against it within 15 days from the date of receipt of such information. The information shall be in the form of a notice in Form A.
Mr. Borbode, please satisfy me that how when a national highway
Yes.
for the purpose of acquisition, because national highway always speaks of acquisition of land.
Yes, it is direct acquisition of land.
Direct acquisition. of
Direct
land.
acquisition of.
So
unlike
how
my lord-
this concept of requisition comes in?
Yeah.
Because section 3, rule 4,
Yes.
etc. says about requisition.
Requisition, yes.
Law also says that state cannot, under the guise of requisition, continue dominion over someone's property for an indefinite period of time, because that would be a fraud on the power conferred on the government. If the government wants to take over the property for an indefinite period of time, the government must acquire the property, but it cannot use the power of requisition, which is exercisable by the government only for a public purpose, which is of a transitory character.
Yes, that is settled position. That is settled position.
And law says national highway is to be declared and it is forever.
Forever. No, my lord, that Bangalore Development Authority decision. That Bangalore Development.
Because here you have that responded to the other petition, both are periodic patta holders.
No, periodic patta holders.
Now let us see your.
Yes,
I'm not really satisfied with your affidavit. No.
Yes. My lord, we say
It has not answered anything.
No, my lord.
Let us see paragraph 6 also.
Paragraph
again.
6, yes.
No. iPad.
With regard to so and so, the answer independent respectfully states that the acquisition of private land for the purpose of construction of flyover at Mission Sariyali, Tezpur has already
He is
commenced.
speaking about acquisition.
Yes.
And the steps you are taking of requisition.
No, requisition is the initial stage. It will now culminate.
Additional Deputy Commissioner speaking requisition. Okay, let us see.
Yes. Now, Lordship will kindly come, my lord. Let me read it, my lord.
Acquisition of private land.
Yeah, the requiring department in this case is.
No, read from very beginning. I will not stop you.
Yeah. The answering department respectfully states that the acquisition of private land for the purpose of construction of flyover at Mission Sariyali, Tezpur has already commenced under the provision of Assam Land So-and-so Act 1964. The requiring department in this case is Public Works Department, Building and NH Government of Assam. The Chief Engineer, PWD Assam, by his letter dated 1st of July 2021, communicated for acquisition of land as per provisions of Assam Land So-and-so 64. And hence, in compliance to the requirements of the acquiring department, the acquisition of land has commenced under provisions of the said act. Moreover, although the provisions of the 1964 Act are being followed for acquisition of the land, the appropriate provisions of the Right to Fair Compensation Act 2013 are being followed for assessment of the compensation to the interested persons and disbursement thereon. It is also mentioned herewith that the same provisions of the Right to Fair Compensation Act 2013 are being followed for assessment of compensation to the interested persons, even in case of land acquisition under the provisions of National Highways Act 1956.
So where is the decision to acquire the land under Section 6 of the Assam Requisition and Acquisition Act 1964? Where is the decision?
That, my lord, will have to bring it.
Please show it.
Yes.
And as soon as the decision is taken,
Yes.
you have to follow the procedure of 1894 Act. Since it is repealed, so it is Section 213.
200.
Then if the 213 comes in, then all these procedures have to be followed.
Yes. Now, my lord.
You cannot skip over,
Yes.
make a jump, leapfrogging
Yes.
from Section 6, leapfrogging 2013 Act to directly 2013 rules.
Yes.
Without following the provisions of 2013 Act, assuming for the purpose of argument, provisions of 2013 Act is applicable, divorce to 1956 Act. Now, how can you leapfrog? If your Section 6 says the decision is taken to acquire the land, this is let us assume for a moment your order Section 3 notice. Okay, perfect. But the decision is to be taken to acquire the land. As soon as you take the decision to acquire the land, the provisions of 1894 Act comes in because of subsection 3.
Yes. Now. Yes.
You are speaking about rules, right? See, are being followed. Where? Tell me. Show me. Are being followed
Moreover, although the provisions of are being followed for acquisition of land, the appropriate provisions of the right to fair compensation and transparency in land acquisition and rehabilitation and settlement act 2013 are being followed.
Are being followed.
Satisfy me.
Now
With
here,
the land acquisition case record, satisfy me.
yes, then my lord, I will have to protect
Making a statement in affidavit,
my lord, yes.
such a serious statement,
Then absolutely.
is it
Now-
not? Let us satisfy ourselves.
Now, my lord.
You, Mr. Borbuzai, as well as this court.
Now, my lord, so far as my lord, applicability of 1964 Act vis-a-vis the compensation that is to be awarded under, because at the end of the day, it is the compensation.
Have you assessed any compensation anyway?
Yes, here it appears to be so. Now,
Tell the assessed compensation
no, we have,
to Mr. Ganguly. If he is satisfied, we will
Lord,
close the proceeding.
I have the
If
instructions.
he is
my lord.
satisfied, we will close the proceeding. We will not enter into that.
No, my lord, because my lord, we have said very clearly in paragraph 10, we are not opposing development at any stage.
No, but
Why should we, my lord?
State as an eminent domain can
Eminent.
take over any property.
yes.
You do not have to,
Lordship,
your objection will not stand.
will not stand.
But only thing is that 300A.
300 my lord.
Right.
That, the rigor
That
of
constitutional
300
right is available.
Lordship.
So they have to take, they cannot
Lord, the
expropriate your property without following the procedure of law.
entire,
Now, as soon as, yes, section 3 may come in. Okay, requisition. But at some point of time, they have to take the decision to acquire the land.
yes, my lord.
And as soon as they take the decision to acquire the land, the provisions of 2013 Act comes in.
Lordship.
Now, Mr. Borpurjai has to satisfy all these procedures like 4, 5A,
Impact assessment
6,
study, additional
6.
solicium.
Even I
Yes,
go by the old act.
yes,
I am not very familiar with 2013 Act. There are more stringent provisions.
yes,
Even we go by the 1894 Act,
Yes.
4 notification,
yes,
5A notice, then 6 declaration. Even if you invoke 17.4, still you have to follow certain provisions.
yes, yes.
This additional district commissioner is saying he is following the provision. So let
Now,
him satisfy me.
Yes, now, yes, that aspect of the matter perhaps may not incorporated. There is a notification of the state of Assam with the approval of the cabinet. Which,
So because Mr. Borbuzai, this
Yes.
kind of cases are coming in.
no,
I
absolutely.
want to get myself satisfied.
No, no, definitely. Now, my lord, that notification says that in all cases of acquisition, my lord, the state will undertake the exercise under the provisions of 1964 Act. But the quantum of, my lord, compensation that is to be awarded, my lord. to
The
the person-
notification is divorce the act. Prime officer.
But that has not.
You
been
are
challenged.
bypassing section, no,
It has not been challenged. And
no, not
and-
required, even if that, no, not even challenged, that is not required, it is a notification only. We have the 1964 Act before us. If the notification is directly divorce 1964 Act, that notification wants to leapfrog from section 3 to directly to the assessment of compensation.
Yeah.
Then it is divorce 1964 Act.
yes, 64 Act, my lord. it says-
Even if we take that you are following. I'm
Now-
not,
Yes, now,
but I have not been able to make 2 plus 2 4.
now, my lord, section 6, my lord, lordship is, my lord, disturbed by this provision of, my lord, section 6, subsection 3, which says, my lord, subject to the provisions of this act. On such vesting,
No, before that section 6,
Yes, section
6 1,
6 1, yeah,
6 1.
yes.
Because where any land has been requisitioned under section 3, the state government may use or deal with it in such manner as may appear to it to be expedient and may acquire.
Acquire such land and may acquire. So therefore, yes, lordship is correct. Even I also admit here, my lord.
Such land by publishing in the official gazette.
Yes,
Right.
a notice to the
A
effect
notice to that effect.
that the state government has
Decided to acquire. Where is that notice?
Now, yes,
Official gazette.
yes. Now, what has happened here?
This cannot be bypassed by way
Yes,
of
yes, yes,
notification.
absolutely.
Absolutely.
Absolutely, yes, yes, I take it, yes. Now, Lordship will kindly see. My lord, my lord,
I am not averse to any amicable settlement between the landholder and the state. I am making it clear. If Mr. Ganguly is satisfied with the compensation assessed by you and it is acceptable, we are not. But when it comes to dealing with the provisions, we have to,
yes. Now,
that is what I am.
yes, so the exercise contemplated under the 1964 Act, my lord, is of two tier. First, requisition, which is temporary in nature, lordship is correct. Then, my lord, acquire. Acquire means, my lord, the requisition, I am making an intention, I am the government, I am making an intention that I want this land.
I want ownership as well as possession.
Possession,
Requisition is only possession.
possession. I take possession.
And that is temporary.
Temporary, absolutely correct.
Defense of India Act, yes. Some military installations.
Yes, yes.
Suppose in Manipur, disturbing situation, one battalion is to be accommodated.
Yes,
They will requisition land.
yes,
They will install the battalion. As
absolutely.
soon as the normalcy returns, they will go back,
Go back. That is a
giving back the land to the
Yes.
owners. That is requisition.
that is requisition with a specific purpose and intent. Now here, my lord, the act itself says Assam land requisition and acquisition.
Okay.
So yes, lordship is correct. Now what lordship is, my lord,
But
not fi-
also at the same time, it is
Yes.
national highway.
Yeah. Yes, now what lordship is not finding herein, lordship has found, my lord, the requisition order. The steps taken by the authorities, that is the collector.
Forget about requisition.
Yes,
Where is the decision to acquire?
decision to acquire. Now this is
That in a gazette notification.
this is the, my lord.
Which one?
My lord, lordship will see. My lord, that
Which one?
my lord, at
43,
page
page
43,
43.
43.
43.
Because of the amended petition, I am getting disturbed.
Yes,
Every time I go
Decision
to
is
the
already-
original petition.
yes, yes. I am taking up the amended petition, my lord.
No, page 43, requisition.
Requisition.
No,
Section
requisition,
3.
no, requisition, the decision, lordship is asking for, kindly see, my lord. This is a notification, SRA number so and so.
Under rule 4 and section 3.
Yes, section 3.
It does not speak about section 6(1).
No, section 6(1) will be another notification. That is my submission. It is
No,
not
no.
there.
Where is is this requisition compensation?
No, requisition, my lord, they have requisition it, they have assessed the compensation, my lord, and my lord, now the second step will be, my lord, issuance of a notification, my lord, order under section 6, which I am not finding in the affidavit, although a statement has been made.
Statement, mere statement of a
Yes,
additional
yes, yes.
deputy
Lordship is
commissioner
correct. Yes,
saying that they are following the provisions of 2013 Act is not going to satisfy this court.
now, if my lord comes to paragraph 7, what is happening? My lord, lordship will kindly say they are not averse to acquisition process. The
Right, I am saying that. I am also not averse.
No, my lord, now they are only, my lord, they are challenging the notice whereby, my lord, the general notice has been issued and, my lord, the enforcers have been, my lord, asked to vacate their land. Lordship will kindly see paragraph 7. What is going on actually in the field? Page 54. Running page 54. Running page 54, my lord. Paragraph 7 of the affidavit. Down below, my lord. That with regard to the so-and-so, deponent states that detailed land survey for the purpose of land acquisition has been conducted by the circle officer and has submitted proposal accordingly. As per the proposal, it is submitted that the petitioner, now here comes the petitioner. Petitioner Srimati Daljit Kaur does not have possession over Dag number 15, Patta number 2 of village so-and-so. She claims, my lord, that she has she is the absolute owner. On record, it is there, my lord. She is the pattadar, but she does not have the possession. The details are furnished here with. Land lordship will kindly see A, my lord. land schedule, dark number
Get the
15.
records of land acquisition case number.
No, yes, so what is happening on field is that, my lord, with regard to acquisition of land, my lord, if their land is patta land is acquired, they will be compensated. Now, it is not the case here, my lord. The case in lease is, my lord, that they have, my lord, transgressed upon government land, which are now, my lord, sought to be, my
Okay,
lord.
in the case records of LA case number 1 of
Lords, in
2022, that will clear.
in items 23 and 24, my lords, the petitioners in those two items are not covered under the notification dated 9/9, notification dated
No, this
43.
is the previous kind of.
Let them clarify whether they are part of the acquisition process or not. No, that's all, my lord.
You have not filed the affidavit?
No.
There-
Affidavit is not filed, but my lord, this affidavit lordship can
No, my
definitely
lord,
take.
because there is nothing as far as those two items are concerned.
Those
there is
two
no-
petitioners
nothing, my
say
lord.
nothing.
Nothing, my lord.
No, those two petitioners, my lord, with regard to the fact, my lord, that acquiring of land has taken place, my lord.
No, they are served with what?
O-
They are served
Only
with
that
what?
general notice, my lord, which we assailed at the very beginning.
Yes, so it is our case also, my lord, that we are not going to disturb any, my lord, patadars.
Now, if it is supposed
Yes,
whether this general notice will stand. Even assume, let us assume Rule 18 is applicable. Let us assume for a moment. Will this, where is the vernacular? In the
yes, in the amended, my lord.
in 4597. 4597.
Yes,
Page 41. Will it stand the scrutiny of law? In a case of encroacher, pure encroacher, I could understand.
no, lordship will kindly.
Whether this page 41 will
It will sustain.
stand the scrutiny of law.
Yes, lordship, kindly see. Yeah,
Okay, we'll
right.
decide.
Yeah.
We'll decide then. If you are supporting, make an argument.
Because in their affidavit, they have not.
Since you have not submitted any affidavit in these two cases,
In their affidavit, they have not
we
stated
can
as to
proceed
what
with this case.
part I have encroached.
If no affidavit is required and page 41, you think that they will be applicable to the petitioner concerned.
No, my lord.
To the only petitioner, I'm not saying that any other people. The page 41 notice will stand the law.
Lordship will kindly see
Or
that.
because it says nothing. Okay, if you want to file affidavit, it's okay. Otherwise, if you
My
can
lord,
they say that without any affidavit, this will be made applicable against the petitioner.
Lordship will kindly bear with my submission.
Right.
My lord, yes, what I am submitting, we will be filing affidavit in the subsequent to, lordship kindly, two affidavits. One affidavit has been filed, number one. And in the both, the next two cases, we will be filing.
Identify that
Yes,
he is,
will filing. and-
despite he is a periodic patta holder,
Yes,
and on field inspection, we have found that 10 lessons of land are unauthorizedly encroached by
yes,
this
yes,
petitioner.
we will file the affidavit.
That
Yes,
things should come up.
Yes, yes.
This kind of general notice, it may be applicable for a normal encroacher who has nothing.
My lord, here, what,
Here is a case, if you examine this notice from the standpoint of Rule 18, neither under Rule 2, Sub-Rule 2, nor under Sub-Rule 3, this prima facie, this will not stand the scrutiny of law.
now, my lord, what?
Prima facie.
Yes, prima
But
facie.
Mr. Borpoje can still argue that it can,
My lord.
no issue.
Now, from the affidavit we have filed in one of the cases, what has come out is that, my lord, we have never disowned their contention that they are not the patradars. We say they are the patradars. And so far as their patta land is concerned, they will be duly compensated.
Right.
Yes, Lordship, I do not stop here even. Now, what is happening on site is that, my lord, apart from the patta land, with patta, the law is clear. I cannot even touch their land with regard to patta. Apart from their patta land, they have, my lord, constructed sheds, my lord, tea stalls and all near the highway.
Then come up with a field inspection report and a photograph.
We will file affidavit.
I'll hardly give then 48 hours time to Mr. Gantul.
Roadside land, rule 18, even notice is not required.
Absolutely.
Even notice is not required. I am not going to argue that.
Roadside land is reserved.
Yes.
Right.
I am not going to argue that even. Yes.
But with this notice,
Yes.
with this notice, I don't think,
Yes.
because had it been somebody who was encroaching without any land in his name,
Yes.
yes, they are periodic patta holders. But while holding one katha, they have suppose encroached into another 10 lesas, which is reserved for, come up with that report,
Yes.
show
Yes.
that this man and this man is encroaching in the process of holding their periodic patta land, have encroached into reserve land, reserved for road. Then 18(2) comes in.
Yes. Now that has been clearly spelled out in the affidavit which we have.
That has not dealt with the other two petitions.
No, therefore, my lord, we will file two separate affidavits in. Then, my lord, in all the three.
And this also all this combination of Land Requisition and Acquisition Act, NH Act, 2013 Act, and the decision under 6(1).
Yes.
Please place on record.
Yes, definitely.
Because these things are found to be happening
Yes.
in all the cases.
Yes. 2013 Act is not resorted to because of a standing notification. No, I'm making a faithful submission before this one I will go. Now, 1964 Act provides for a short time.
So, no, out of 60 cases, suppose listed, 10 cases are of this nature.
Yes.
And that is, this is to be, things have to be, the creases have to be ironed out.
Yes.
Otherwise, crease will remain, everybody will have grievance. Am I clear?
Absolutely. Absolutely.
And to my knowledge, if I am not wrong,
Yes.
this kind of requisition process has already been interdicted by other benches of this court.
So other benches, even Supreme Court is clear. You cannot.
And I have also indicated
Yes.
one judgment. There are more.
Yes.
I have just found one.
Yes. The Supreme Court says you cannot requisition a land in perpetuity.
And
There cannot be
otherwise,
prolonged requisition.
Section 2,
Yes.
NH Act, it is highway means highway. And highway is always forever, unless central government withdraws.
Yes.
But both possession and ownership goes, even if the state central government decides to not to continue the national highway, that will not revert back to the original owner.
Yes.
Law is also settled.
Settled. Yes.
So it is gone forever.
Ever.
This shortcut requisition process, then leapfrogging into the rules for assessment is divorce the provisions of 1964 Act.
No, 64, I will satisfy my lord. That's subsection.
Heard Mr. A. Ganguly Lanek Kasarpada petitioners and Mr. R. Borpujari. We are conscious that national highway is to be constructed
Yes.
expeditiously.
Yes.
But at the same time, Article 300A is not to be violated.
No, absolutely. Absolutely.
And Mr. R. Borpujari Lanek standing as a revenue department. And PWD also.
No, my lord.
Okay. Revenue department for all the. And Mr. N. Gustam, junior government advocate, Assam, for the state respondents. Mr. Borpujari has submitted that counter affidavit on behalf of the state respondents in WPC 4596/2022 and 4597/2022 will be filed within 2 weeks' time.
My lord, 2 weeks.
2 weeks' time.
Yes, yes.
Post of. He has further submitted that he'll place on record. The
the original record.
compliance.
Yes.
6-1. Place on record.
No, Lordship will kindly indicate that I will produce the original records pertaining to.
And he has submitted that he will also make endeavor to obtain the records, original records of land acquisition, case number
1 of 2022.
1 of 2022.
2022 of Sonitpur district.
Pertaining to pertaining to these petition.
That will please, my lord. Yes.
List the cases when.
Let it be on 6th, my lord, 6th of March.
6th of March.
6th of March, yes.
The interim orders may continue, my lord.
6th of March. Okay. 6th of March.
Madam.
You just explain to me on the basis of laws, Mr. Barbujari. I want to know that how this marriage has happened between 1964 Act, 1956 Act, 2013 Act. How this marriage or amalgamation,
Yes, madam.
whatever,
Yes, madam.
right?
Yes, madam.
Can happen.
Absolutely. Because we are now.
Because I have been facing difficulties in many cases.
No, absolutely.
My lord, the interim orders may continue
Interim orders passed earlier shall continue till the next.
in all the 3 cases.
Lordship may kindly note, my lord, that Bangalore Development Authority citation, my lord, that is. My lord,
On the next date, I'll give at least 10 citations that this kind of thing is colorable exercise of power and fraud on the part of the government.
I'll try to satisfy my lord.
The similar state acts were there in the Tamil Nadu, in the state of Tamil Nadu, my lordships are perhaps aware. The validating act had to be passed, my lords, because it was struck down by the High Court.
No, otherwise it is perfectly all right. But thing is that compliance of the provisions.
No, compliance of the.
6.
No,
You have to go through 6.
Absolutely, Lordship, because Lordship is disturbed because of the reason that we have annexed the preliminary notification that is under section 3 and having not brought on record the section 6. And section 6, once section 6 notification issued, finally vest with the state government. And then, my lord, 1894 will apply. So far as-
1894 will apply.
apply so far as compensation is concerned. Now we are giving compensation under 2013 Act, whatever is the quantum. If assuming my lord, under the
So what does this subsection 3 says?
subsection 3, therefore, yes. It is very tricky, my lord, subsection 3. Section 6, subsection 3, subject to the provisions of this act on such vesting, once it has finally vested with the state government, on publication of section 6 notification, the provisions of land acquisition with the rules framed under so far as may be applied to such land. Once it has finally vested. Now we say, my lord, that the compensation, at the end of the day, you will get the compensation. The compensation, you are getting the highest amount of compensation under the 2013 Act. And for that, the state government has also, my lord, framed the 2015 Transparency Act rules, my lord, which give a specific parameter. If they are entitled to 500 rupees, otherwise 100, they will get 500. This is the logic, only to speed up infrastructure for them. At the end of the day, they will not be losers. They will be getting more. I'm so obliged.
And how, one more. This route, that route, otherwise national highway is to be acquired. under National Highways Act. How you can go through another route through the state government PWD department? Please explain to me
Yes,
on the basis in black and white,
absolutely,
not
absolutely.
with the oral submission of Mr.
Yes,
Professor.
yes, yes. Absolutely, absolutely. I will bring on record.
Because this is everywhere now.
Yes. Therefore, my lord, I will make an endeavor, my lord, to produce the original record. Lordship will see the decision-making process. That's it.
This may happen, this may curtail the number of litigations also.
Absolutely, absolutely.
At least 5,000 in future.
5,000. In fact, in the affidavit.
5,000 litigation in future.
My lord, in the solitary affidavit, we have stated, my lord, that 73% of the persons therein have, my lord, they have received the compensation.
No, that is not the issue.
Number 25.
The issue is compliance.
Yes,
Article
I'm
300A.
absolutely. I'm so obliged.
Lordship, as per the last order dated 12/1/24. They were supposed to file an affidavit. I've been informed that we can. Item 25.
Has been sent for vetting.
Muslim Ali.
Muslim.
What? Forest royalty.
No, this is a different GST case. He has a lot of cases.
Because this name is very familiar.
Yes.
Okay, GST. Now he is GST. Mr. R.J. Raslani, Council for the Petition is present. Yes.
We need 10 more days.
Oh, Mr. R.J. Das.
Yes, Lordship.
I think
Yes.
some problem.
You will.
List the case before any other bench will.
Deeply obliged.
26.
Made your lordship, my make.
Yes, madam.
Look the last order, my lord, this honorable court. I have received instruction according.
Having regard to the contents of the
Madam.
order 17/6 passed in petition. Okay, I remember something.
The representation lordship. Whether they have filed representation.
Any order passed?
After the lordship, the election was postponed, my lord. We have
By
directed
whom?
to correct the voter list, my lord.
No, no, by whom? By whom?
Lordship may kindly have the instruction bonds, lordship, page 9, my lord. I have page netted. We have directed them to correct the voter list, my lord.
Use the. So come to page 26.
Lordship.
The order is at page 28. That writ petition was disposed of on withdrawal in the writ petition.
Lordship.
Then since the election of the society is on 26/2022, respondent number 2 may look into the grievances of the petitioner if the same is brought to his notice by tomorrow, 18/6, and take appropriate action as may be warranted under the law.
Lordship.
So what did he did after receipt of this application? He postponed.
Lordship, he has written, passed this order, Lordship, 12 July order, page 9 order, my lord.
No, that I could understand, but
Yes,
there
after that, the ARCS has stopped all the process. Due to correction of voter list, my lord. This is the annex in repetition, page 29, my lord. This is the impugn here, my lord. Page 29.
29.
Lordship.
Otherwise, this is This phase 29
Yes.
is
Yeah,
not
post.
sustainable.
Lordship.
But whether this was as directed by the Register of Cooperative Societies or not, that is what we wanted to know.
We have
Because Assistant Register of Cooperative Societies,
Lordship.
because he uses the word as per this High Court's order, which is not
This is not
correct.
correct, my lord.
So he cannot
Yes, sir.
shoot
My lord. There, I also understand.
on
my
the
lord.
soldier of this court.
If he didn't understand what this honorable
So
court has
whatever,
said,
express it is bad.
my lord. Lordship.
Whether
My
the
lordship,
representation was submitted
Submitted.
as per the High Court order on 18/6.
Lordship. It was
Right.
submitted.
If the registrar has passed an order already, the deferring
Lordship.
it is perfectly all right.
My lord. That's why the register had written the pass the order, Lordship, the last paragraph, my lord, page 9 of the.
That is on 12/7,
Yes, Lordship.
madam. Whether on 18/7 he had passed any order
Eight-
deferring the election, that's
Yeah.
all.
This order of 18/6.
Only that is challenged.
Only that is challenging, my
Ah,
lord.
and this page 31 order,
Lordship.
prima facie, this is not correct. Mr. Counsel, even if we set aside this order, your operation will be successful, patient will be dead because there is another order.
My lord. My lord
You're
may
challenging.
dispose of the matter directing the authorities to hold the
Mr.
AGM, my lord.
You give a copy of this order, 12/7. Are you aware of the case,
Which case, Lordship?
Mr. Counsel? Are you aware of the case?
Yes, Lordship.
Where is Mr. Bhuya?
He's on election court number 1
Bring him,
of like Lordship.
because he might not be aware of the case.
My lord.
Let Mr. A.R. Bhuya come in.
Lordship.
27. 27.
Yes,
Please, Lordship. We challenge here, our name was struck of the company's name by an order under rule, by exercising the rule 116 of the
okay. Interim order has been passed.
Lordship.
They are not filing an affidavit.
No,
It is revenue or district commissioner?
basically it's a revenue matters.
Commissioner, Lordship.
Huh?
They had challenged the order of the district commissioner.
District commissioner.
Response number 2.
Impugn order passed by the deputy
District
commissioner.
commissioner, Lordship. On 15/07/2019.
Which is the impugn order?
Lordship. Page 67.
Page 67.
15/7/2019.
Okay, name of the existing pattadar. Pabhojan Tea Company against the schedule of land mentioned below is struck off.
209 vigas of land, Lordship.
Hmm.
And Lordship is aware, no, is not, is a treaty law held by this honorable court. Is held by this honorable court. That 116 cannot be exercised because for non-possession of the land, that not been criteria for exercising this
It
rule.
is some company petition.
Yes, Lord.
Company petition.
We are originally the land stands in the name of Warranty Limited by an order of this company's court. It comes under Jam Sovereign by a demerger scheme.
That page 36 order.
Yes, 32, Lordship.
32. I think that these lands are mentioned therein.
Yes, Lordship. Lordship will find page
let us-
52.
Page 50.
The 7 tea estate transferred to us. 7 tea estates.
Where is the reflection
Page
of these
page 50,
dark numbers?
page 52, Lordship. This is the relates to Doidam tea estate. Doidam, DHO.
Yes, 52. Doidam.
Yes.
Doidam. Okay,
Yes.
Doidam.
Yeah,
Okay.
yes.
Whatever.
The total land is 9,001 viga.
Is there any reflection there?
Yes,
Specific reflection.
yes.
Where?
Serial number 4, Lordship will find.
Serial number 4.
Page 65.
No. In this schedule of this order, page
Yes.
52.
Lordship will find is page 52.
52.
52.
Yodham,
Yes, 52.
this 209 bighas.
Yes. Serial number 4, Lordship will find TP1, WLN number 206.
TP1. Okay.
WLN number 206. This is the subject matter of that impugned order.
And you mean to say that this 209 bighas
Yes.
is part of this TP1 WLA 206?
It was mutated in your name, Lordship. There is an order of the edition.
So it is out of this 1751 bighas?
Yes.
Okay.
And Lordship will find at page 65, that is a mutation order granted by the additional deputy commissioner. For instance, is projected and indicated that this Duodam Tea Estate mutation was granted in favor of the petitioner company.
Okay, that entire 900,
Yes,
9,900.
yes, Lordship. Page 65. By an order dated 20th of February.
Yes, Mr. Borua.
Just one of the judgment, Lordship, will play. Justice answer it.
Let District Commissioner respond, because it is his own order.
Yes.
Page 65, you say, by this land has been mutated.
Yes.
Yes.
If I abandon the land, then only 116 would come.
Okay, tell me what is the decision 116?
Yes, Lord. Paragraph 5, Lordship can read.
Any decision?
Yes, 2008, 4 jailer.
2008,
Jailer.
4,
Jailer. 134.
134.
134.
Yes, Mr. Borua.
Paragraph 5,
In
Lordship.
2 weeks. File a counter affidavit, whatever.
Yes.
You are changing your own position. You mutated by page 65. And
Then strike.
later on, making a U-turn, page 67 order.
Strike.
It is your case.
Yes, Lordship.
You are not responding.
There's several orders passed by this on court, Your Lordship. You will find in the ordership. Always they seek time for instruction.
No, this is the third date only.
Yes.
Third.
Instruction is on the way, Your Lordship.
It is third date.
Let us switch.
Mr. Borua,
Yes, we will file within 2 weeks.
go through the petition, then obtain specific instruction.
Yes.
Otherwise, appears to be a not very complicated case. If Deputy Commissioner finds something different, that is different. Or
Order.
Mr. B. Dr. Lawrence, Senior Counsel, assisted by Mr. S. Dekal, Learned Counsel for the petitioner, D. Hajarika, standing as a revenue for the respondent number 1, S. Borua, Learned Junior Government Advocate Assam for the respondent number 2 to 4. Full stop. The
14 March.
it is already recorded in 1811-2022 order, right?
Yes. Lordship.
What is your story? You are Warren.
I'm James Warren. James Warren Tea Limited.
Okay. The petitioner, Messrs. James Warren Tea Limited has
Para 5.
Where is the order?
Company page 32 is order.
It is the case of the petitioner that by virtue of an order dated 16/12/2023 passed in company petition 10/2013
notice. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
within bracket warranty limited versus Messrs Warranty Limited and another versus Messrs James Warranty Limited. Bracket close. Comma. A the landed properties mentioned in part 2 of Schedule B of the company petition number 10/2013. Property, huh? And property. And actually, immovable, comma, freehold and leasehold, comma, mention its points. Came to be vested in favor of the petitioner company. First of the landed properties included an area of land measuring 1751B -2K -12L covered by T periodic patta number 1 within bracket WLA number 206 bracket close within DHOEDAAM T estate. Thue Dam is 52 out here. Situate at the village Pahojan, Moja Abjan, district Tinsukia. It is the case of the petitioner that out of the said 1751-2K 12L, comma, sorry, it is the case of the petitioner that the entire (1751B -2K -12L) was part of Guedam Tea Estate, comma, which consisted of 9001B 3K 10L, consist of areas measuring. Full stop. It is a case of the petitioner that the respondent number two by his order dated 20/02/2015 mutated the entire area of land measuring 9001B -3K -10L of Thuedam Tea Estate in favor of the petitioner company. Full stop. By the imperial order dated 11/6/2019, comma, an area of land measuring a part of 9001B 3K 10L and one seven five one B 2K 12L. Comma measuring 209B 4K 13L. Struck out from the register in purported exercise of powers conferred under Rule 116 of the Settlement Rules framed under Assam Land and Revenue Regulation 1883. Postcode. It is the case of the petitioner, comma, the impugn order is in conflict with the decision of this court in Bhavani Shankar Bagaria versus State of Assam and others, comma, reported in 2008 for ZLR 134. Full stop. Mr. A notice to the respondents were issued on 18/11/2022. Full stop. The respondent number 2 has not yet filed any response. Full stop. Mr. Borua, learned Junior Government Advocate, Assam, has sought for 2 weeks' time to file a response on behalf of the file accountability on behalf of the respondent number 2. Full stop. Lays the case on. Yes.
5, 6, 7, I am here, Your Lordship, of March.
6/3/2024.
Lord.
The interim order passed earlier shall continue till the next date of this.
Grateful, Lordship.
Item 30.
Yes.
Your Lordship. Here, Lordship, in the while issuing notice, Your Lordship, on the motion. This Honorable Court has passed an order on 25th of July 2023. A detailed order has been passed, staying the demolition.
Exchange of pleading is complete.
Actually, in fact, the matter has came up before this Honorable Court by a stay application filed by respondent number 5. But the municipality. Stay vacating petition. Filed by the respondent number 5, the private respondent.
No, Mala, we have not filed IA. We filed affidavit opposition. Mala, main cracks, Mala, the division bench directed the municipality earlier to take press measurement and take action on that. Municipality took press measurement, they found deviation, they issued demolition notice. They have come to this court saying that some item may be compoundable. Municipality not considered.
You are a municipal board.
Municipal board. We are for private person.
Private. Who
Now-
represents municipal board?
Well, I don't know. Anyway, my lord.
Yes, they are the main.
Now, my question is this, whether it is compoundable or not, my question is this is not compoundable. Let municipality decide it, my lord, after hearing both the parties.
No, who represents municipal board?
They are not the authority to say
Municipal
so,
board,
Your
government-
Lordship.
Roy.
SS Roy.
All Mr. S.S. Roy.
Name shown.
Is his name is shown?
Yes.
Because,
Is he available?
because by the initial order, Lordship will find.
Anyway, you are enjoying interim order.
No. So what the direction by this Honorable Court is, by the initial order, Lordship will find a para 12 of the order, last page.
Okay, paragraph 12.
Yes.
So it is Mr. Roy who can respond.
Yeah, response. To
And
apply
what
this
kind of
code.
deviation?
My lord,
There is some deviation, Your Lordship, admittedly.
One floor itself.
No, this is a small house, Your Lordship.
Setbacks.
Setback, Your Lordship.
Okay.
said that no one has objected except respondent number 5, who has himself encroached our land. The civil suit is filed.
When you are available, 5-3 then or 6-3?
Lordship,
5-3. You'll be on 6-3, right?
Lordship.
6-3, okay. Rita, agal agal logai dibo. B. Dotto. Senior counsel assisted by Mr. S. Deka, Learned Counsel for the petitioner, Mr. G. N. Pravela, Learned Senior Counsel assisted by Mr.
HK Sharma.
H.K. Sharma for the respond number
5.
5. Full stop. By order dated 12
July
25/7/2023.
23.
In the order dated. Sorry. By the order. Respond number 2 was directed to apprise the court as to whether the deviation so mentioned in the demolition notice is compoundable or not, and if so, to what extent the same is compoundable. Full stop. Mr. S.S. Roy, Learned Counsel, represents the respond number 2. Full stop. But Mr. Roy is found absent today on call. Full stop. Let this court for the case be listed again on 6/3/2023. Full stop. Mr. Roy shall obtain the instructions in deference to the order dated 25/7/2023. Post of the Learned Counsel appearing for the parties shall apprise Mr. Roy as regards the order passed today.
Interim order complete.
The interim order passed earlier shall
No.
continue till. Okay.
Hello, 86.
Yes, Mr. Bhuya.
My lord, I have gone through the order of the order passed by the registrar, but my lord, I have a very little and limited submission, my lord. My lord, this honorable court passed an order that immediately after the order, the appellant are required to file an representation before the registered cooperative societies. Now, if just for a moment, my lord, if my lord may be pleased to peruse the order.
I have seen.
My lord. Now, my
That
lord.
is why I have asked a specific question to MS Bora.
My lord.
Right. But still, your assisting counsel was not aware of the proceeding.
My lord.
So that is why I asked for your presence.
My lord.
If 18/6/2000, whatever, 18/6, they had submitted a representation.
My lord.
These are available.
My lord.
That two petitioners.
My lord.
As
directed by this honorable court.
liberty granted by the court,
My lord.
they submitted a representation. My specific query was to MS Bora whether registrar had deferred.
My lord.
On the basis of the representation received, whether the registrar had deferred the election
My lord.
on 18/6/2022.
No, my lord.
So I had asked for.
My lord. The registrar has not.
I would
deferred,
ask
my
for
lord.
that.
Yes,
instruction.
yes, my lord.
Because at a later point of time, he has cancelled.
My lord.
That is one matter.
That is one matter. Correct. My lord.
That is what I have.
Lord,
So you have understood.
my lord,
Okay. Heard Mr. A. Bhuyan, Learned Counsel for the petition, and MS M.D. Bora, Standing Counsel, Corporation 1, 2, 4, 5, and 6.
lordship.
And MS S. Borua, Learned Junior, Government Advocate Assam for the respond number 3. Full stop. As per instruction, MS Bora, Learned Standing Counsel, Corporation Department has obtained instructions. MS Bora, Learned Counsel for the petition.
Respondent.
Sorry, Learned Standing Counsel, Corporation Department, has submitted that the instructions she has received, from the instructions she has received, it transfers that
pursuant to the order dated 17/6/2022 passed in WPC number 4052/2022, comma, two of the petitioners therein Hijat, Atikul Islam,
And two others, three.
and Altab Uddin submitted a representation before the Register of Cooperative Societies, Assam, on 18/6/2022. Full stop. From the instructions, it is not clear as to whether the Register of Cooperative Societies, Assam, had passed any order on 18/6/2022 or 19/6/2022, deferring the election of the society, comma, schedule on 26/2022. That is what?
My
Lordship. My lord.
Lays the case. MS Bora has paid for listing of the case after 10 days. Lays the case accordingly. Did you what are they? The instructions placed by MS Bora by communication number so and so, dated so and so, are kept with the case record.
My lord. Deeply obliged, Lordship.
Obliged.
Item number 31.
Mr. Bhuya, even if it is not that Assistant Register of Cooperative Society goes,
my lord.
but the Register of Cooperative Societies passed at a later point of time will come in. It is
My
up
lord.
to you.
My lord, I know. Obliged, my lord.
Yes.
Yeah, please, your lordship. My lord will recall this matter pertains to.
I don't
revenue
recall
map.
anything.
This matter pertains to the missing revenue maps, my lord, which has come in the way of mutation of the petitioners before your lordship. In Durga Sarovar village, your lordships had directed them to obtain and submit
Not
instructions.
available.
But this 2007-8, we bought the property, my lord. We are not able to make any use of it, my lord. This is, my lord, I mean, though I don't have a fundamental right, my lord, my constitutional rights under 300, my lord, are clearly attracted here, my lord. I'm being deprived of making any use of the property. I can't avail a loan, my lord.
Now let Mr. Pukon,
Yes, my lord.
MS Hajoriga,
Lordship.
then you bring this on by way of a sort affidavit that not available. Then we can go for some alternative
Yes, yes, my lord.
way. It could be a direction for making survey.
Yes, Lord.
And my lord, at least.
This is not a small exercise otherwise. If new exercise is to be done, that involves many things.
But the cadastral map should be available at least. The cadastral map should be available at least, my lord, with the DC for the entire.
See, Mr. You yourself there making a categorical statement. It is not available. What to do? Let it come on affidavit, then we can say not available. Not available. Whether it is in existence or not in existence. And find out.
And why it is not available, that is at least.
Not available in the office of the Guwahati Revenue Service.
It may be available.
Now,
in
question is whether it is in existence or not in existence. If it is in existence and it is available in some other place other than the Guwahati Revenue Circle Office,
Lordship.
then what is the problem? But here this is Mr. Pukon. This is by Joint Director of Surveys, not by the Deputy Commissioner. There is some problem. See the two letters. One is by Joint Director of Surveys. The other is by Director of Land Records Surveys.
They are saying the second sentence, however, the matter will be pursued to
Then,
the
Miss
district
Borua.
administration.
Ms. Borua, you come in. MS Hazarika, show the letter to MS Borua. Read the Joint Director of Service letter.
Yes. With reference to the letter on the subject cited, I would like to inform you that the delays.
Art Mr. A. Pukon Lanak, Council for the Petitioner, G. Hazarika, Lawrence Standing Council, Revenue and Disaster Management Department for the respond number 1 and 5, and Mr. MS Borua, Lanak Junior Government Advocate Assam for the respond number 2 to 4.
May I please, Lordship? We have submitted before a instruction that the map cannot be traced down. Before,
You have submitted?
yes, on.
They have submitted that, they have written a letter to Joint Director of Survey regarding this map.
Yeah, regarding this map.
We don't have any letter.
My lords,
Is it letter?
one of your orders, my lord, note
One-
that.
According
okay,
on the basis of that letter.
What is November order,
Implemented as part.
11th December order takes note of this, my lord.
It is perhaps available. Let me see. December 11. The subject matter of the writ petition is with regard to the revenue map in respect of a plot of land measuring 8 acres, 1 katha, 15 lasses, a order to the covered by dark number 135 within bracket OLD old bracket close stroke 210 within bracket new pata number 88 of village Durga Harbor, Mauja Jalukbari. Full stop. The instructions have been placed from the office of the Deputy Commissioner. Offices of the Deputy Commissioner, the Joint Director of Service, Assam, and the Director of Land Records and Service, etc., Assam, that revenue map pertaining to the subject plot is not available in their offices. Full stop. MS Hazarika, Standing Council Revenue and Disaster Management Department, and MS Borua, Junior Government Advocate Assam, have submitted that they will obtain instruction in the event of non-availability of the revenue map. What measures are available for the state authorities to produce the revenue map? I think now their ball should be in their court.
My lord, it's been.
All
passed
should
from
be in
one-
their court again.
Yes, yes. But it's been passed from one department to the other. It's
Now all three. Release the case. On. Yes, but that.
My lord, 22nd March, if convenient.
Okay, 22 to 2024. Am I Hazarika?
Hello.
You are the authorities who have to.
But they have said that they don't know.
Not available is one thing. Now bring it into existence by undertaking the necessary exercise.
I have been left high and dry for my lord, almost 17 years now.
Every litigant here.
Item 32. Obliged.
Lordship, in this matter, I am preparing for the Water Resource Department, Lordship. Although we have received the
What is your case?
regarding land compensation, Lordship. Compensation, Lordship.
You are respond number 3 or
Water resource, Lordship.
water resource?
I'm respond number 2, 5.
Okay, Deputy Commissioner has filed an affidavit. Mr. Das, you might be in big trouble.
Lordship. Because department is not clear whether the land of the petitioner was acquired.
Deputy Commissioner clarified.
Deputy Commissioner has clarified, Lordship. But if you
Dike.
yes, Lordship.
His land is in Dike.
But if your Lordship follows page 63 of the writ petition, that is the letter written by the executive engineer to the Deputy Commissioner, starting from page 61, Lordship.
Whatever, you have
Some allegations are there against
filed.
page 63. That
You
is
are in big trouble for 60 years.
Lordship.
You might be.
Dike has been constructed in the year 53, 54.
Deputy
But-
Commissioner said that in 63.
Yes, Lordship.
In 63,
54, 55 dike has been constructed.
but in 63, his lands were requisition
Land was recreation
in
63
1963.
and 71 the claim of the petitioner.
Whatever.
Petitioner.
Your act is
Yes, Lordship.
filed.
Yes, Lordship. At least
Mr.
M.K. Das.
M.K. Das, petitioner. Miss Asboro. Junior government will assign for respondent 1, 3, and 6. RM Das, Standing Council,
2 and 5.
Water Resources Department for the respondent number 2 and 5, and MS and Bordeaux.
4.
Standing Council, Revenue and Force Department for the respondent number 4. In the affidavit in opposition, the respondent number 3 has stated that as per report of the circle officer, Dibrugarh East Revenue Circle, areas of land measuring 2B0K9L of DAG number 8 and 0B0K 16.5L of DAG number 9, belonging to the petitioner, were requisitioned in the year 1963. First of MS Mr. Das, Standing Council, Water Resources Department, has sought for and is granted 3 weeks time to file counter affidavit on behalf of the respondent Water Resource Department. So release the case. The price law, release the case. Is gone. Release the case after 3%. On a date review.
May I please illustrate? Well, some land has been acquired, my lord, and in respect of acquired land, assessment was done. And accordingly, my lord, our NF Railway, my lord, page 25, your lordship kindly see, that amount has been sanctioned, but the sanctioned amount has not been released.
Who has not released?
My lord, NF Railway, my lord, page
Yes.
25, my.
We have received instruction, the process is, process of payment, making payment to the account of the district commissioner is going on. And it will take some days of 20 to 30, within 1 month, it will be completed.
Okay, Railway Board has allotted the fund now.
Yes.
Well, let it become after sometimes, my lord.
Within 20 to 30, within 1 month, it will.
My lord, another 2 cases, my lord. Same sanction letter has been annexed, my lord. That may be listed.
A Manna, council for a petition. And Bodoloi, repeat for your S. Borua.
3.
You appear as a standing
CGC.
CGC. Okay.
And for state, Mr. Esburua can.
Mr.
Esburua, he is.
Oh,
next in
Asburua,
another-
Mr. Asburali. Okay. And Bordoloi.
And for 3.
Okay. 3.
3.
Okay. Mr. Asburua. 4. And MS Asburua. That is CDC for the respondent number 1. Good again, MS Borua and CDC has submitted on instruction that the railway board has allotted the fund and the same is process for making payment online in the account of the district commissioner Gwalpara. She has thus submitted for listing of the case after 4 weeks in order to enable her to obtain up-to-date instructions regarding disbursement of the amount of rupees
9 lakh
8,053 to the petitioners. This is the case on.
My lord, along with my lord, another 2 cases.
Why taking here? Where this get the matters listed? Like the court.
Item number 54.
There is no representation on behalf of the petitioners today on call. As Borua like it was 1, 3, 4, 5 and Boruloi 2 are present.
Sorry.
Yes.
Last of the notice was issued for it.
Extra copy not served till now.
Not sir.
I'll serve more to this.
Okay, আমি মন্ডল লিখি দিব কিন্তু নাম্বারখিনি রিপিট করব নাম কেটা খালি এস বড়ুয়া সিনিয়র গভর্নমেন্ট অ্যাডভোকেট এন্ড বড়ুয়া Miss Bordolo and Miss Borua have submitted that extra copies of the writ petition along with annexer, have not been served upon them in deference to the order dated 19/1/2024. And as such, the interim order is to be vacated. Okay.
I'll start today itself.
Okay, Mr. Mondal and council for the petitioner has submitted that he will serve extra copies of the petition during the course of the day. Post of release the case after 3 weeks for filing of counter affidavit by the respondents. The interim order parcel shall continue till the next date of test. Obviously.
Number 36.
Can it be disposed?
Lordship, I have obtained instructions. There is a difficulty with the department. The appeal was dismissed on the ground of delay. Lordship,
But so many coordinate benches, this court have been passing all the orders.
no, Lordship, what I mean, in normal case, there is not, because he prepared appeal. An appeal was dismissed on the ground of delay. And there is a dictate of the Supreme Court that delay.
Smith Climb.
Lordship,
Smith Climb.
no, Lordship.
Glaxo.
Yes, Lord.
Smith Climb Glaxo.
No, Lordship, here they have Singh Enterprise, Lordship.
Singh Enterprise, there are the Smith Climb Glaxo.
Yes, two just.
Singh Enterprise 1995.
Yes, Lord.
1995.
Singh, 2008.
2008. And that is holding the field.
And 2025 PMI, this is Glaxo Smith claim.
Glaxo. Smith Climb.
And on the basis of this judgment, our High Court has also. So unless Lordship direction comes from this noble court.
Difficult to overcome also.
So this is the difficulty. Otherwise, Lordship, another opportunity.
Because we have been disposing of otherwise.
Otherwise, Lordship, if we could not file appeal, then there could have been.
Then I don't know, rightly or wrongly, I dispose of.
Lordship, in where the appeal has not been preferred, simply they come before this honorable court. Then many cases have been passed where we have directed.
Mr. Counsel, they are objecting to it.
And Lordship.
You have preferred the appeal.
And Lordship, he can apply for phrase registration. That can be.
My lord, already I have already paid my all the dues and all the taxes, my lord, whatever I left. And second, subsequently, my lord, even we go to the second appellate forum where it was situated, my lord, still it was not, the bench was not constituted.
Even the Supreme Court has admitted.
I don't know, but
even the Supreme Court has admitted.
Yes, my lord.
And that even under 142.
But my lord, there is a provision I have already categorically mentioned. My lord, as per section 30 and rule 23, if the dues or the taxes I have been paid, then there is no outer limit for revocation of cancellation. So my lord, I humble request.
I know, but our hands are also tied, Mr.
Yes, my lord, but I will pray for my lord.
No. 30 is also same thing. 30 is also same thing.
Yes, my lord.
30 days from the date of service of the cancellation order, proviso says for a period not exceeding 30 days.
30 days.
Right. And if it goes beyond, then Singh Enterprise as well as Smith Klein Glaxo.
Yes.
Supreme Court has said if it goes beyond the ordinary period of limitation plus extended period of limitation. And thereafter, if the writ petition is filed under Article 226, even then, we under Article 142 cannot. That is the situation now.
Yes, my lord.
Getting stricter and stricter.
Yes.
Take your advice to your client. What he is suggesting is that go for praise. Some benefits will be lost. And that is not for someone else's fault.
Yes, ma'am.
It is your own fault.
Yes, but my lord, he is a layman and due to his
Layman,
online procedure.
that layman is not an excuse.
Yes, my lord. He is not.
Mr. S. Somal, Council for the petitioner. K. Fukan, standing counsel. Central Government Council for the respondent number 1 and Mr. S. C. Kyle, learned. Standing counsel GST for the respondent number 2, 3, and 4. Right, huh? Mr. Kyle, learned counsel, standing counsel, GST, has submitted that in view of the decisions in Singh Enterprise versus
Singh Enterprise versus Commissioner of Central Excise, Jamshedpur.
Reported in
2008-221 ELT 163 Supreme Court.
and GlaxoSmithKline
Lots.
versus so and so.
Page 29, it is mentioned.
Okay, is there?
Lots.
Oh, it is there. EMI to side over, heritage side over, SCC side over. The period of delay. The appeal, which was dismissed due to its filing beyond the period of limitation. The petition is not pending. So stop. Mr. Sharma and counsel for the petitioner has sought a wish time to obtain to complete his instructions.
Yes, my lord.
Early is the case. After a week.
Yes, yes, sir. Deeply obliged, man.
Advise your client.
Yes.
Item number 37. Well, in this case, I have received some instruction. They have filed an additional affidavit. On that also, I need some instruction in the matter. So I'll go to 3 weeks time. In the meantime, I'll
Whether
get the
election process has proceeded.
No, only the application has been submitted, Your Worship.
Okay, let him come up with the
Lord,
instruction. If they come up with the instruction, then that is their instruction.
Yes.
Heard Mr. B. Dottal and senior counsel, assisted by Mr. S. Dekal and counsel for the petitioner. S. Borua. Mr. S. Borua and junior government advocate Assam, respond number 1, Mr. H. Kiras, and standing counsel. GHC for the respond number 2 to 5. Full stop. Mr. Das has standing counsel GHC has submitted that he has received the necessary instructions in respect of the petition. So stop. He has submitted that. Since the petition has submitted,
File an
additional affidavit today, he needs how much time?
Within 3 weeks, I'll file the affidavit also. My lord.
He needs
Everything.
some more time. 3 weeks time to file the counter affidavit on behalf counter affidavit traversing the contentions made in the writ petition and in the additional affidavit.
One
This is the
ex-
case
15th,
15-3.
Fine, my lord.
15-3. 2024. The interim order passed earlier.
Lord, one extra copy of the affidavit,
Okay.
additional affidavit, Dutta did.
Shall continue till the next date of listing.
Lord, get
Mr. Deka, Learned Counsel for the petitioner shall serve an extra copy of the additional affidavit to Mr. Das, standing counsel GHC.
Lord,
By
get
tomorrow.
Deeply. 38 to 40.
This writ petition relates to the abolition of arbitrator under National Highway Act. Earlier case was there where specific
Yes, did you see?
Lordship, I appear on behalf of Miss R. Borua, Lordships. My lord.
R.
Bora. Lordship, my lord, due to some problem, she could not be attended today, Lordship. And even then she informed me that my lord, that the constitution of the arbitration bench, Lordship, it was not been
Mr. Nath.
Yes.
Because I have to rise today at exactly 4:15 because of. So Thursday,
Lordship, my lord, some kind.
Thursday,
My lordship.
we'll dispose of this.
Lordship, my lord, that only because of my lord that she told me that the arbitrator was not appointed.
Okay, on Thursday.
Lordship.
Mr. D.K. Nath, Learned Counsel for the petitioner. MS Bordo Hazarika or Bordo, please obtain up to date instruction
Regarding the appointment
as
of arbiter.
Revenue Department. Get the instruction whether anything has progressed or not.
Lordship, no information is with me, Lordship.
Okay, get those
At the
at
latest
least,
information, the earlier name was rejected as he has.
get those so papers available with you.
No, Lordship.
Oh, get those papers. J. Henry Lines Council appearing on behalf of MS R. Bora Lines Standing Council NHI Distill MSS Borua Lines Judicial Government of Assam and MSG Hazurika Lines Standing Council Revenue Department. Full stop. As sought for the Barga Land Council for the parties list the cases on Thursday. 22. Gimana?
22.
All the detail will be clear. 1 week.
22.
Thursday is 22nd.
No, we have to see that. Or
That is correct.
okay. Thursday.
Order second numbers 41 and
Matter is ready regarding service.
Matter?
Ready regarding service. Notices has been served. Your
Served, Lordship. Lordship, steps was to be taken by the petitioners, which has been completed.
What is the subject?
In this WPC 20722, our main grievance was that no confidence motion has been taken against the president, and that was not complied with.
Are you in the office?
No, I don't think so.
Lordship.
Although I do not.
Purpose will be served.
Yeah,
You are not in the office, you are out of office.
might have become infractious.
Already has become, not might,
Lordship,
must have become infant.
Lordship, I am for the respond number 8 in item number.
You are also out.
Lordship, but there is no instruction regarding that. We have not obtained. So,
What?
Lordship,
All these sponsors have been dissolved.
Yeah.
Lordship,
Be the president or ward member. Whoever has brought the no confidence motion, they are also out. The president against whom the no confidence motion was brought, he is also out.
Lordship, some time may be granted. We will,
What purpose?
no, Lordship, we will take the
They
instruction.
would.
Lordship, we will try to take. We'll take the instruction because there is no instruction from our client. Lordship,
Get the notification then. You have no instruction and I'll close.
Almost 5 years has gone, so.
MS,
N-word.
Bora, get the instruction. Since
Lordship,
they are seeking instruction. Now, this court will close.
Lordship, government notification issued on 3 to.
My lord, my case also became infectious because on 5th of February, the period is elapsed and the government have already, the videos have already taken over, the entire DC has taken over. That is a notification.
You are in which case?
No, I was in another case, one from
Okay.
Lakhimpur.
Give the notification then. I'll close this. If they are seeking instruction from the client. Mr. R.P. Sharma, you tell your case, please.
My case was one from Lakhimpur, my lord.
Which one?
No, it is not.
Oh, it is not in the list.
I am in different case, item 47 that I wanted to upgrade, my lord, but no, I want to fix another.
Is it available?
Yes. Lordship, a short date may be given. We
What?
Lordship, because there is no instruction from us.
Okay, material instructions. Okay, for that purpose we can give. If you want material instruction,
Lordship,
Friday. If something has remained, then definitely. If the Learned Council need material instruction, I'll adjourn the matter till Friday. Mr. Sharma is smiling. Heard Mr. MS.
S. Dasgupta.
They have not understood
I have.
what I am indicating.
I have understood.
MS S. Roy.
CSL regards the material section.
S. Roy, learned. You are petitioner where?
In item in WPC 207 2022.
Learned counsel for the petition in 41. And who is the petitioner in 42?
Lordship, I am the petitioner.
Mr.
M.R. Sharma.
M.R. Sharma, learned counsel for the petition in 42. Have submitted that they need instruction from their clients as to whether they are still in office. Pursuant to resolution of the panchayats, all the panchayat bodies by notification dated 3/2/2024 of the Panchayat and Rural Development Department. There is a case on Friday. Cases on Friday.
Should the interim order may be extended?
No. No.
Item 43.
Lordship, notice was issued upon respondent 5 for paper publication, which was completed,
Okay.
and also filed a affidavit on 11/10/23. It's annexure A 135 page, 133 page.
Let me see office note first. Upon respond number 5 to 10. What is the subject matter otherwise? Mr. Bora, you appear for whom?
Respondent number 4, Lord.
4.
Will file the affidavit, Lordship.
Respondent number 4. Dalimi Garo.
Garo.
Okay. Heard Mr.
A Banerjee.
A. Banerjee. Learned counsel for the petitioner. G. Hazarika. Standing counsel, Revenue Department for the respondent number 1. Mr. N. Goswami, learned junior government Assam for the respondent number 2 and 3. And Mr. M. K. Bora, learned counsel for the respondent number 4. Post of Mr. Sharma. Sharma. You're Mr. Sharma, right?
Banerjee.
Banerjee. Has submitted that an affidavit in respect of service of notice upon the respondent number 5.
Yes.
Only 5?
Yes.
Okay. 5 has been in a subsidiary manner through paper publication. Upon the respondent number 5 has been affected, an affidavit to that effect, an affidavit, a compliance affidavit to that effect has been filed. Full stop. As per the affidavit, comma, the notice upon the respondent number 5 has been served in the substituted manner by publishing the same in 2 newspapers, comma, Ohomia Protein in its issue dated 6/10/2023, and the Times of India in its issue dated 3/10/2023. Thus, in deference to the order dated 15/9/2023. In view of the same, comma, the service of notice upon the respondent number 5 is found to be complete. None has appeared for the respondent number 5 till date. Full stop. Now, anything left? Okay. Forensic justice is the case again after 2 weeks. Then we'll proceed ex parte.
Obliged, Lord.
My lord, I wanted the upgradation, but that could not be possible. I wanted an urgent matter to be upgraded, that could not be possible, my lord. So can it be?
Okay, what was the matter? You
My lord,
mentioned
no confidence motion was called by us, 9 members of the municipal board. The other day-
municipal board,
Yes,
not panchayat.
no, they obstructed and we got the persons picked up by police. Ultimately, my lord, it could.
Ajit,
Item 48.
item 58, 48.
48. Your lordship can read the order dated 12/1/2010.
Okay, Friday?
Can it be on Thursday, my lord?
No, already many matters listed. I have seen.
Friday is fixed item. my
We'll
lord.
try then thereafter on Tuesday, if not possible on Friday.
Let it on fixed matter. my lord.
Friday. 48. On the request of Mr. R.P. Sharma and Council for the petitioner, list the senior council for the petitioner, list the case on Friday.
It's
48.
fixed matter, my lord. I think only 10 minutes only.
Only thing is this, my lord.
No, I have to rise because I cannot stay for any.
Only notice may be issued, my lord.
No,
Because,
1
my lord,
minute
from
we'll do
November-
Wednesday or Monday.
My lord, from November, my lord, only notice may go, my lord, let the government.
No, without say, this court does not issue notice without looking into the case.
Witness them.
Wednesday is not possible. Come on, please.
My lord.
Okay, Wednesday. Wednesday. That is the early. No, I don't fix up. Yes, at 2.
Item 44 and 45.
MSA click দিব item number কিমান আছিল MSA
46, man.
46 46 click দিব is the case on the request of
Item 58 million, market case million, settlement. So it may on Friday, my lord.
next week Mr.
Then Monday, my lord.
Monday
Lordship, for item 44 and 45, Lordship.
Stay vacating petition.
Stay vacating petition that forest royalty matter.
Yes,
Lordship had fixed the matter.
Monday.
Can it be on Tuesday, Lordship? Monday.
We don't feel such urgency here.
The interim order that may be called.
Interim order
44 and 45.
RM okay P Hazarika petitioner RM Das standing council water resource for the respondents on the request of so and so list the cases on Monday.
Lord, the interim order.
Interim order passed shall continue.
My lord, in item number 50, my lord, interim order may be 50. 50.
Okay, 50.
My lord,
Mr.
HK Sharma.
Okay. 50. No. Oh, yes.
Monday. Interim only continue.
Okay, interim order.
47.
Continue করে দিব for 50.
My item is 47, my lord.
Interim order
Interim order, my lord, till today, my lord.
today.
Yes, my lord.
Okay.
Here,
Okay, T Islam. After 1 week. The interim order passed earlier.
here item number 49, may list first week of March.
Okay, on the prayer of Mr.
Associate.
Associate Learning Council for the petition list the case in the first week of March on a date to be fixed by the